contested case hearing for the 30-meter telescope project, a proceeding for the State of Hawaii, DLNR, Board of Land and Natural Resources.
You good? You good, Professor?
Yes.
Okay, can we get started, please? Mr. Lui Kwan, is there?
So I have a couple things I wanted to raise.
Okay.
Just one thing, very quickly. So
Wait just a minute. We're starting the hearing, please. Go ahead, Mr. Lui Kwan.
Judge, we appreciate the hearing officer's monitoring of the hearing to make it as efficient as possible. But again, we'll know for the record that, much of the cross-examination by the petitioners have, really been almost a redirect or actually just a cumulative or repetition of was already Mr. Flores's lengthy and detailed written direct testimony.
Okay, thank you.
And again, we understand that I think Ms. Flores has conflicts in his schedule because of his teaching. And we note that I think Tuesdays and Thursdays were dates that he was actually saying he was unavailable. And in order to maybe move this along and make sure we're able to complete his cross.
All right, thank you. I appreciate that. Mr. Ching?
Good afternoon, Mr. Forrest.
Aloha.
May I call you Kalani?
Sure.
You did say you were familiar with the CDUA.
Yes.
Do you have any knowledge whether it has been amended since the first contested case hearing?
It has not been amended.
Does the CUA contain any corporate financial information regarding the third-party beneficiary, which is the TMT Observatory Corporation, that you know of?
None that I know of.
Do you have any knowledge of the appeal against DLNR possibly on the so-called TMT sublease?
Yes.
Excuse me.
I know it's vague, but
Excuse me, Professor. Why is this relevant to this hearing?
Because the sublease is one of the cornerstones of this whole process, in that, for instance, the outcome of this tribunal will be, I believe, important in whether a sublease is present or is executed or not, or a new sublease, because I believe that the old one has now been canceled out, revoked, or the consent for it has been revoked. But if I can move on to other questions.
All right, thank you.
Are you familiar with the so-called emergency rule that was promulgated?
can you be specific to which emergency rules are you referring to?
This is the one I believe that restricted people from the mountain between 10 p.m. and 4 a.m. and that they couldn't have sleeping bags, tents, cooking utensils, and stoves?
Yes.
What can you tell about that? What can you tell the hearing about that case?
Well, I guess I just give the outcome of the case that
Well, okay, before you go on, let me ask you, were you the plaintiff in that case?
I mean, I'm not sure what the terminology was, but I was in that case. I guess you would say I wasn't a defendant, so I must be the plaintiff. Yes.
So then, can you tell us about your version of the case?
Excuse me, I'm not familiar with the case, so what case are we talking about? I don't know it.
Can you tell the hearing what the name of that case was?
I know it was in Kalani Flores, and I believe the defendants was the state of Hawaii, BLNR. I don't know the case number. I don't have that with me. It was in regards to whether these emergency rules were propagated by BLNR at the time when the Mauna Kea protectors were on the mountain. These emergency rules were implemented, and we had gone to court to challenge the validity of those rules. And in the environmental court of the Third Circuit and Judge Ibarra's court, his final decision was that the rules were in fact the state through the BNR had not followed proper procedures in the implementations of those rules, so he declared those rules invalid. And
Thank you.
I'm not sure if it's called proper procedures, but to some extent, he invalidated the emergency rules based upon his decision.
Thank you. Are you familiar with Hawaiian cultural practitioners doing rituals and celebrations and activities like that during solstices and equinoxes?
Yes.
What times of the day do those activities take place in or at?
They can, it depends on the time of that particular astronomical event. It could be any time during the day or times of the night. So there's no one specific time per se. But some culture practitioners will practice at a certain time, but for some the time could vary from particular hours of the day and night.
Would it be true that, according with what you just stated, that these activities may go throughout the day and the night?
Yes.
Okay, now, one of the items of mitigation is that the TMT will allow the practice of Hawaiian rights, or whichever way they say it, for 4 days out of the year. Would 4 days out of the year accommodate people who are up there doing day and night activities?
Not as written, no.
Thank you. I have no further questions.
Thank you, Mr. Ching. Ms. Aluli?
Mr. Flores, I wanted to discuss with you the analysis or table that you have presented on page 7 and 8 of your witness direct testimony regarding, it's identified as table 4.1. And it appears to be a compilation of items that were identified in the CDUA for which the CDUA stated that there was no applicability to these components of the various management plans and subplans that were adopted by the University of Hawaii and the BLNR. Is that a correct description of what this table depicts?
Yes.
And you've testified, this is not a complete list, however, is that correct?
That's correct.
So if we were to look at the CDUA, which is Exhibit 4 R-1 from pages 4-1. I just want to direct the court specifically to the page numbers because there is in the CDUA a specific reference. Pages 4-1 to 4-8 in Exhibit R1. It's about 7 pages of various management plans and land use plans that the CDUA identifies and discusses in a sort of an Excel spreadsheet. Do you see that there in front of you in the CDUA application?
You said 4-1 to 4-8
Yes.
in the CDUA. I don't see it in the main section of the CDUA. Would it be in the back section?
Let me pull it up on my computer. It's in the appendix, excuse me. And it's pages. And the reason I'm asking is because your table 4-1 is only a page at most. So my understanding of what you have presented in that table is that it's an excerpt or just a smaller group of It begins on page of the appendix, it begins on page 4-1 to R1, which is part of the record. And it goes to 4-13.
Okay, so do you know which appendix that is referenced at the bottom is? Or the TMT management plan?
Yeah.
Okay. So
So you've
So I guess the question,
a
yes.
table that's at best a page.
yes, so it doesn't. The table presented here is just a extraction from what's found in the CDUA. It's not the complete table.
Okay, so because in the CDUA application, it's maybe 7 to 8 pages, is that correct?
Yes.
And your analysis is that the CDUA misrepresents some of those identifiers as being not applicable, and specifically in your witness direct testimony, you highlight FLU, and I assume that means future land use -2, in which it is identified, and this is at page 8 of your witness direct testimony, in which the DLNR, or this, excuse me, the university has identified the need to develop a map with land use zones as being not applicable to the TMT application. You disagree with that representation made by the applicant?
Right. I believe this, as written, it says not applicable to this project. I believe is directly applicable to in this project.
And are you aware of whether any land use map has ever, in fact, been between 2010 when these management or 2009 and 2010, when these management plans were adopted? Was there subsequently a land use map that was drawn to make this no longer applicable?
Well, there's a number of maps, but this type of map that's specific in this in reference FLU to this particular management action plan. I know that particular land use map has not been done, and it's also mentioned in the annual reports to BLNR as one of the actions that hasn't been completed yet.
And did you attach any of those the annual report that references that as being in a management action that hasn't taken place? I know you identified one of them as being in your exhibits. Does this one talk about it? B.02H.
Okay, so I do have in B02H. Let me see here. And then in the appendix of this report, so going back, this report was an annual report that was submitted to the BLNR on June 12, 2015. This is the UH's 2015 annual report that was submitted for the board as part of their requirements, I would say. So on Appendix A, page 26, it's listed as one of the action items, one of the action items. This is consideration for future land use. And you have FLU 1, FLU 2, 3, 4, 5, 6, 7. None of these have been completed yet.
And that is on page, what, of B02H?
It's in the Appendix A, page 26 of that particular exhibit.
Okay, thank you very much. Now, I also note that you have provided the implementation plan as your exhibit B.02Z. Is that correct?
Yes.
And found on that implementation plan, if you were to look at page, boy, and this is, I'm sorry that I'm struggling, page 4-1, which is again another appendix to the implementation plan, in which FLU-2 is designated as being immediate.
You know, I don't see a 4-, sometimes I see alphas. But if you go back to the exhibit we have up here, which talks about immediate. And that exhibit is B02H. This is the 2015 annual report. So if you go into FLU2, so describe what needs to be done.
Yes.
It says short term.
Yes,
If you
yes.
read in the comments, this was originally listed for immediate implementation. However, the task will require additional data gathered from baseline surveys of the resources.
So the implementation plan, that is your Exhibit Z,
Yes.
was dated 2010, is that correct?
Yes.
And this annual report is some 5 years later, 2015, is that correct?
Yes.
And are you aware of how it is that the Office of Mauna Kea Management was able to amend the management actions as set forth in the duly adopted management plans so as to make the land use map call for an FLU-2 short-term versus immediate?
I'm not sure how. See, if you look at short term is between 1 and 3 years, if I'm not mistaken. Immediate is 4 to 6 years. So how and when that?
Are you sure when you say immediate that it connotes a longer term process than something short term?
Okay, so
Immediate connotes how many years?
okay, so if we go back to this management, I'm gonna go reference back to this management plan because then I'm getting foggy right here. As for the years. Okay, so so we go to Exhibit B02Z, which is the implementation plan for the CMP and its associated sub-plans. If you go to page 5 outlines the schedules and priorities. In these management action items, in these plans, they have identified when these action items should be done and completed. And so if you go through them, this is right under section 2.1, schedule and priorities. The implementation on schedule for the Mauna Kea CMP identifies a time frame for which each management action will be implemented and accomplished. The implementation schedule ranges from ongoing, currently being implemented, immediate, 1 to 3 years, short-term, 4 to 6 years, midterm, 7 to 9 years, to long-term, 10 plus years.
Thank you. So basically, the Office of Mauna Kea Management in their 2015 report has now said that it is no longer immediate, but short-term. Therefore, no longer requiring completion within 1 to 3 years. Is that correct?
That's correct.
And in actuality, are you aware of any way by which the management plans of 2010 were amended to accommodate this change from immediate to short-term in the land use map?
For that particular FLU2, I haven't seen any explanation other than what's written here of why they're changing it, but no other explanation of are they allowed to change it.
And the only other time you've seen it referenced is in the 2011 CDUA application, in which they state it is not applicable. Is that correct?
Yes.
And again, did you have any explanation, was any explanation referenced, for example, in the CDUA application as to why, other than to say it was not applicable on those multiple tables within that application form?
I didn't see any explanation as to why it's not applicable.
Now, you have also testified in your witness direct testimony that you believe that the environmental impact statement, which was noticed in your exhibit, what is the exhibit where you have the, B.02K is your exhibit, which shows the EIS preparation notice, which was submitted for the cancellation of the 2 existing subleases, master leases to the University of Hawaii in 2013, and the issuance of a new master lease. Is it correct that that then resulted in an EIS preparation notice as referenced by your Exhibit K?
It's kind of a compound question, but I believe it's yes to everything you said.
Okay, sorry, it is, lots of clauses. I noticed that attached to it, you submitted a portion, or is it the entirety of the, I don't know what that paper is called, that's attached to the letter?
It's
What-
so what I have here is attached to this. It's just part of this document. It's from the EIS preparation notice regarding the Mauna Kea Science Reserve Master Lease.
And are you aware of the fact that within that portion of the environmental assessment EIS preparation notice, there is no reference to the proposed sublease with TMT?
At this moment, I can't recall if there's a reference or not to the sublease in this particular notice.
And this notice was made some 2 years ago, is that correct? In December 2014, it's now January 2017.
Yes.
As far as you are aware, has anything come of that notice in terms of a posting on the Office of Environmental Quality Control's website or the actual EIS itself or draft EIS?
As of this date, first of all, this is just a notice that they're going to prepare a EIS. As of this date today, a draft EIS has not been prepared in this regard, and neither has a final EIS been prepared to this regard.
And why do you believe that this EIS should be completed before the issuance of a conditional use permit as sought by the applicant?
You know, throughout this, well, from the Hawaii State Supreme Court's ruling regarding that invalidated the CDUA, throughout this contested case hearing, you keep hearing the cart before the horse. This time we have so much carts, we don't even have enough horses. And the reason why I say this is that the purpose of this required EIS has to do with the master lease. and the master lease ends in 2033. There's still an uncertainty whether a new master lease can be issued out. So why is the university putting forth a project? In this case, the project is the TMT Observatory, which has been clearly stated and not disputed at all in any of the testimony that the lifespan of this project was 50 years or more, which would exceed the existing, it's called the master lease, but existing general lease. Why would you approve a project that exceeds the existing master lease beyond 2033? Wouldn't it be beneficial to all parties involved, particularly the TIO, to know that the state can actually issue, or will be able to issue a lease beyond there that would allow a project like this to go beyond 2033? That's why to me it's so significant that this process should be done first. And that would determine whether any new projects can or cannot go beyond 2033. But you have to do the EIS first to determine that, because the subleases are co-terminus with the master lease, or in this case, what we refer to as the general lease. If the general lease ends and there's no new lease, and technically you can't extend this general lease, all the subleases end as such. And if they end as required by the comprehensive management plan and other regulations, these observatories will go through a process of decommissioning. And if the TMT was built, that would apply to them as well.
Well, these leases, as has been testified to by Dr. McLaren, these existing subleases, with the exception of the one issued to TMT, none of them provide for decommissioning. Is that not so?
Well, I'm not sure if that's correctly stated as such, because it's part of one of the sub-plans of the CMP is a decommissioning plan. But what we have to look at in the subleases is the language within the subleases. So within the language of the subleases, there's some gray areas as to what extent the decommissioning will, what the subleaser, those who have the subleases, the language in some of these subleases is very vague as to what extent the decommissioning would be for some of these specific telescopes.
And isn't that the rationale that is given on that notice of intent? If you flip to the third page, they have the lineup in an Excel spreadsheet and their rationale for seeking the termination of the existing leases to have a new master lease is that they don't have any decommissioning commitments with the existing subleases?
From my understanding, the existing telescopes do not have like a decommissioning fund in place.
Nor do they have a decommissioning obligation, if one were to read the university's position in that notice of intent.
Well, I believe some of the telescopes have some decommissioning commitments in the language of their subleases, but not necessarily all of them. It's going back to what is the extent of their decommissioning are we talking about that's in question. Is it a full decommissioning where the entire telescope and base and everything is removed? Is it a partial removal, or does the BNR or DNR buy them out? So there's variations on decommissioning But the language is very vague in the various subleases.
And if I were to direct your attention, you also state in your witness direct testimony, well, on page 2, you have your lineup of all of these actions that the BLNR needs to do before it issues a permit, amongst which is the completion of this EIS. Is that correct?
Yes.
You've also listed at the bottom of your bullet points that the BLNR needs to ensure that, that Native Hawaiian traditional and customary practices are protected and preserved. Is that correct?
And I don't have the word reserve, but I do say they should be protected.
Well, preserved is the language of the Kapa'akai case. They use both protection and preservation. And in essence, you are seeking to have an analysis of this land use activity be made by the BLNR prior to the issuance of the permit. Is that correct?
Yes.
And have you seen that analysis in the CDUA application?
No.
Have you seen that analysis in the OCCLA's report to the Board of Land and Natural Resources, which was made in 2011?
So in that particular report, the OCCL's report, they do discuss the Kapa'akai as such, but most of the information that's in that report is information that's been extracted from the applicant's documents. And so when we go back to the Kapa'akai analysis, and there's a framework for that analysis as such, and part of that framework on page 3 of my written direct testimony, there's a framework that's outlined as to what is required as part of the Kapa'akai analysis. So I'm not going to go through it all. I'm just going to say, when you look at the frame number 2, agencies are obligated to make an assessment independent of the developer or applicant of impacts on customary and traditional practices of Native Hawaiians. So first of all, the agency that we're referring to is DLNR and BNR as the board of that agency. They're the agency. It says an assessment independent of the developer. The developer is the TMT Corporation, now the TIO. The applicant is the University of Hawaii. It's clear, you look at the CDUA, it tells who's the applicant, University of Hawaii, through the University of Hawaii at Hilo, and it says who is the developer. The state, the agency, DLNR through as well as BLNR are required to do an independent assessment. Not from the UH's, the applicant's documents, not from the TMT's documents. Independent of that, I have not to this date seen any such assessment. And to reconfirm that, or to affirm that, I should say, I submitted an exhibit An exhibit was a request to BLNR to ask for. So while this, in the midst of all this contested case and so forth, I put in a request for a government record directly to DLNR, care of Office of OCCL, and I requested, could I get a copy of your required Kapa'akai analysis in your in your documents.
And what is that exhibit, Mr. Freitas, that you refer us to?
I don't, Mr.
I mean,
Freitas is
excuse
back
me,
there, but
Mr.
Mr.
Flores, I'm
Flores is
sorry.
over here, but that document is B02C and B02C2. And that was the request that I put in. So what I filed as part of B02C2 was what they sent me. A couple this stack of here of papers. I've went through these document by document, and there is no kapa'akai analysis that was done. So in essence, I requested for one. This is what they sent me in response to my request, and there's nothing in here.
And so you filed the entirety of their response as B.02C2?
Yes.
Okay. And you received it when?
Received in July 18th in 2016.
Thank you, Mr. Flores. I have no further questions.
Thank you.
Thank you, Ms. Aluli. Mr. Fergerstrom?
Good afternoon, Kalani.
Aloha.
I'm Hanalei Fergerstrom, Harry Fergerstrom, as I'm addressed in this hearing. We know each other for quite a while.
Yes.
I may have to skip around in my questioning because I'm trying to catch a whole bunch of pieces that create a very large picture. So I want to note again for the record the absence of a court reporter. And I feel this is very disadvantageous to us because no clear record as today's proceedings go is going to be on record today, except for the visual. And if the visual is permitted today, then all visuals that have been taken throughout this hearing should be also considered official record. That being said, I want to say to you that I'm very deeply affected also by what happened to you and your family and your daughter regarding the ancestors on Mauna Kea, and you're having to take responsibility for someone else's action with no regard to you or your family. And I am very troubled by that and very hurt. And I feel the same pain you do because this is what we do feel as true religious practitioners on Mauna Kea. And this entire thing, this whole process is about how to injure us and get away with it. That being said, and I'm truly happy that you, because of your training and your background, knew instinctively what to do to counter this particular spiritual attack and to be able to save your daughter from harm. You would not have been able to do that had you not known the practice and had been a practitioner. I want to note that for the record. I'd also like to state that I recall you stating that in the previous contested case hearing, you were already identified as an expert witness. Is that correct?
Yes.
It's very important to recognize that because you once were. There's no reason why you should not be at this time, even though the hearings officers are not allowing people to be recognized as experts at this particular juncture. To your knowledge, as you would state in your exhibit B02A, do Native Hawaiians by law have a right to continuous practice of their cultural, traditional, religious, to continue practice of cultural, traditional, and religious for religious purposes? Do they have a right by law?
Yes.
I want to bring to your attention, I believe you know this by heart anyway, but it's Article 12, Section 7 of the Constitution of the State of Hawaii regarding traditional and customary rights, where it states, do you have that by chance with you so we can, I want to make sure that I'm not just dreaming this up, but it actually states that.
Yes.
Okay, so if I'm not mistaken, at Article 12, Section 7, it states traditional and customary rights. And it says the state affirms and shall protect all rights customarily and traditionally exercised for subsistence, culture, and religious purpose, and possessed by Ahupua'a tenants who are descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. Subject to the right of the state to regulate such rights. Is that what you read too?
Actually, I'm going to retract my answer that I thought I had it written. I thought it was written here, but it's actually just a narrative about it. So I don't actually have that particular article before me, but based upon what you read, it sounds familiar to me.
Okay. There's a question in this statement that has been alluded to several times by the attorneys for University of Hawaii and TIO that basically tries to elaborate on this statement that it's subject to the right of the state to regulate such rights. And I want to go over that a little bit. Do you know where that line came from, that quotation, subject to the right of the state to regulate such rights?
No.
Okay, just for information's sake, that actually comes out of the past decision, PASH decision. And that in that decision was a reaffirmation of existing rights that the Hawaiian people had under Hawaiian Kingdom law. This little provision, subject to the rights for the state to regulate such right, was an add-on, and it was not a confirmation of an existing right. It was an add-on by the state at that time. And so...
So I'm going to
go ahead.
Object to a certain extent that
okay.
I'm anticipating a question's coming here sometime soon. So if there is a question, I'm willing to answer it.
Okay. In the matters of religious rights, do you agree that only practitioners of these same religions and spiritual beliefs, or people knowledgeable about these religions and spiritual beliefs, can regulate these rights?
Could you, can you, I couldn't quite hear your question, so could you please repeat it again, please?
Sure. And I actually have another way of stating it, but I'll repeat what I just said. In the matters of religious rights, do you agree that beliefs of people knowledgeable of these religions and spiritual beliefs can regulate these rights? In other words, what we're asking here, can is it proper for people who do not know these rights or do not practice religion to set up a procedure of regulation for those rights?
So you have two questions now. So the first question I'm going to answer is, yes, I believe cultural practitioners can regulate those rights.
Okay, and the second part of that question was, do you believe that people who are not familiar with this practice or this culture have a right to make that regulation?
Well, if you don't know the practice, or you're not understand the practice, then it will be seen to me to be very difficult to try to create a rule or law to regulate the practice. And that's how I'm going to answer that question.
Thank you. That's the answer I was looking for. I agree with you. Excuse me. Do you consider the alteration, the destruction of traditional Hawaiian sites to be an act of desecration?
Yes.
You spoke earlier about, well, actually in your opening statements, you were talking about how without permits, the TMT took it upon themselves to go ahead and bulldoze an area. And we've seen photographs of this where they were grinding up the stones, which we have told them were our ancestors. And they did this all without permits. Do you believe that was an act of desecration?
Well, to clarify that statement is that they actually did have a permit that was issued to them, which later went into appeal, and then later they got invalidated. But what they didn't have, and then later they got invalidated. But what they didn't have at that time was a consent to a sublease. So there's two different things here. So you have one is the CDUA, which ended up as a CDUP, Conservation District Use Permit, and the other they needed was a consent to a sublease, and the sublease was between the University of Hawaii and TIO. So they had a permit, but the permit was still under legal appeal, and of course that permit went up to Hawaii State Supreme Court, and they invalidated that permit. But in that interim, they hadn't gone before the board yet regarding the sublease. So that to me was an action that BNR is responsible for, to giving the go-ahead, and TIO is responsible for doing the action when they didn't have legal and authority or possession of the land at the time to do so.
So am I correct to state that the CDUA that they were relying upon was invalidated by the State Supreme Court?
Yes.
Am I also correct to say that the sublease that they were depending upon that gave basically a standing to TIO in this contested case was also invalidated just recently?
It's actually the consent to the sublease.
Yes.
That action was invalidated by the Environmental Court of the Third Circuit by Judge Nakamura.
That's what I believed also.
Yes.
When the state claims that they have a right to regulate your traditional practices, does that include the denial or the cancellation of that right?
I'm not sure. I'm not sure how to answer the question, so I'm just going to say I don't know.
Okay. Well, the law states that they have a right to regulate. I don't believe it says they have a right to cancel or deny that right that is guaranteed by the Constitution. Would that be a safe assumption?
I think I look at it differently. If you read the law, you look at the law, in this particular law you're referring to, the state has an obligation to protect these rights.
And thank you. That was much clearer than I had posed it, that they have an obligation. Thank you for that. You teach Hawaiian language, Hawaiian culture, Hawaiian religious practices, I believe is what your testimony was.
Yes, once again, it's a compound question, and the answer is yes, yes, yes.
Okay, sorry. I'm trying to get a whole bunch in before she throws me out, as she's certainly done before. Anyway, going on. As a cultural practitioner, you know the different areas of the island of Hawaii. Would that be safe to say?
Yes.
That like the Ahupua'as.
Yes.
Do you know of an Ahupua'a known as Kauhi Mauka?
No, I know of an Ahupua'a that's called Ka'ohe.
Aye. I thought so, because I only know it as Kauhi also. I want to bring to your attention that excuse me, I lost my place here. The CDUA that's been in question here was submitted in 2010. Is that correct?
Yes.
And so I found it very interesting in item identified as B36 under the CDUA, there is a map identifying Kauhi Mauka that was done in January 10th, 2011. Do you know how it got into a 2010 document?
No.
And that document, that map was made by a person with the initials MC from an office called OCCL. Would it be reasonable to believe that that MC was Michael Kane from the Office of Coastal Lands and Conservation Lands?
Calls for speculation, so I'm not going to answer.
Okay.
But we can assume that, but I don't know.
Yeah, there's no real identification, but it sure looks suspicious. I am concerned that that map somehow, that was created in 2011, somehow appears in a 2010 document. And I can only assume that that was done by falsely putting it in there. This is why questions are being raised as to the authority of the state of Hawaii, and I'll raise it over and over again until I get a proper answer. Because in the CDUA, it identifies the state of Hawaii as the owner. Such statement like that, when they're questioned, has to be proven. And to that effect, since we don't have a court reporter here today, I'm going to read to you what I put into, I hand-delivered today, because the person who could actually address that properly was my witness, Professor Williamson Chang, that was rejected by this hearing officer, saying that we're not going to discuss these matters. And so to that effect, I wrote, and by the way, I hand-delivered all the parties, including the hearings officer, and to the person who's filling in for Michael Kane now for the records. And it states that it is the demand for a written explanation for the denial of the testimony of Professor Williamson Chang from the Richardson School of Law, University of Hawaii, Manoa.
So I know that I'm not the hearing officer, so, but I am the witness here.
Yes.
I'm also here. I'm going to have to object. I think the hearing officer should object because you're testifying. And I think if you submit something for the record, that's be appropriate. But if you have a question for me regarding what you're doing or what you're explaining, I'm not sure it's appropriate. And I hate to object against you, Mr. Fergerstrom, but
No,
I'm going to object like I would object on anybody who comes here and
certainly.
it's not in a proper, whatever you would say.
Okay.
So I think if you have something to submit for the record, I think that's great. But unless it pertains to a question you're going to ask me, then it probably is not appropriate to try to insert into the record.
Okay, let me see if I can do this.
Examination.
Let me see if I can do this according to the rules that we're playing under right now. Did you receive from myself, hand-delivered to yourself this morning, a copy of a paper that I'm putting into evidence today, entitled, or in the caption area of the sheet, says the demand for written explanation for the denial of testimony of Professor Williamson Chang from the Richardson School of Law, University of Hawaii, Manoa. Did you receive that document this morning?
Yes.
Okay. Do you have a copy of that with you, by chance?
No.
Can we get a copy from him? Yes, please. And please bear with me. I don't know how else to do this. I am trying my best to stay within the parameters of the rules, and yet it's very important because we don't have a court reporter on hand today that I'm not going to miss the opportunity to get it on the record officially. So, since you have a copy of that in front of you, I'm going to read from it and ask you if that's what it says. Would that be all right?
Sure, proceed ahead. And I guess unless the hearing officer or myself intervenes, and I guess
Okay.
proceed until that occurs.
Does it say on the second to the last paragraph on page 1 that on or about the 23rd of January 2017, Harry Fergerstrom, a party of record, called two of his witnesses to testify before this contested case hearing held at the Naniloa Hotel, Crown Room, Hilo, Hawaii? Is that what it says?
Yes.
The following paragraph states that both witnesses were placed into evidentiary submissions on October 10th, 2016. Do you agree that's what it says?
I mean, I agree. I mean, that's what it says, yes.
Thank you. It further states that the hearing officer, Ricky Mehana, presiding, Ms. Amano had ample opportunity to examine the written testimonies filed under the name of Harry Fergerstrom. These records are kept in and online, maintained by Michael King, Office of Conservation and Coastal Lands, Department of Land and Natural Resources. Is that what you read to?
That's what's written, but I'm going to object further because then how does it apply to this cross for me?
Just so I understand, Professor, your objection is as to relevance?
Relevance to my testimony and my written testimony, yes.
So it's relevance and outside the scope of his direct. You can respond, Mr. Ferguson.
Yes, I'm trying to figure out how to and not get thrown out. Okay, so I understand your objection. I certainly understand your right to object. You testified earlier that you referred to a document known as the final environmental impact statement for the TMT Observatory. Is that correct?
Yes.
Okay, in that on page A6, there's what is called the mailing list Appendix A. Is that correct?
I'm not sure because I don't have that document with me.
Does, Mr. Sampson, do you have that document? It's your documents. Or
Unless you can make reference to the document.
Well, yes, I'll just make it simpler, right? It's a list of people that they claim that they contacted as cultural advisors, I guess you could say, or people that were consulted. And the reason I'm asking you that is because they have my name on there, and on page 39 under B35, which is part of the CDUA. And the relativity of this is because I have been what I considered non-correctly denied to present witnesses on items that I believe is very pertinent to this case, which has to do with the lands on Mauna Kea. And I am trying to go within the scope of this, and in the CDUA, it refers to the landowner to be the state of Hawaii, and under lease to the University of Hawaii, under general lease number S4191. Is that your knowledge too?
Yes.
With management delegation to the Office of Mauna Kea Management.
Yes.
It also states that the location of this property is the Mauna Kea Science Reserve, Ka'oi Mauka, Hamakua District. Do you know of a Ka'oi Mauka in Hamakua District?
All my research, I haven't seen that reference on any maps, historical maps, I should say. I've seen it on these recent maps, but not early historical maps.
And this is why it's very troubling me, because this map or this reference was produced in 2011 when the CGOA was submitted in 2010. And so it brings up questions in my mind, because I have with me a copy of the Great Mahele and the Book of Indices that shows that the lands of Kauai, Apua, in the district of Hamakua is Hawaiian Kingdom government lands. Do you know of anything that can be produced, or have you seen anything that can be produced that says that this land was somehow transferred to the so-called state of Hawaii?
What I can confirm is that the lands of Ka'ohe within the Hamakua Mokua, the Hamakua district, at the time of the Mahele, were designated as, I should say, as a result of the Mahele, these lands ended up being designated as government lands of the Kingdom of Hawaii. And what transpired after that as to the exact transfer of these particular lands, I can't speak on that.
Yes, and thank you. I've been trying to search for that kind of mechanism of transfer, a mechanism of conveyance for quite a while now, and I keep bringing this up because I think this is very, very pertinent. Because on any other type of land transaction that I know of in the state, you must have some kind of proof that you actually own it. And so while the state may claim that they somehow overthrew the Hawaiian Kingdom by whatever means, it still does not show a method of conveyance of property. So when they say that they own and have title to, it brings a question to mind as to, can you establish that by law? Like, show something that proves it. And so I'm going to just move on, because again, this is about making record. We'll certainly deal with this at another time. I just want to let you guys know I'm coming. Do you know Professor Williamson Chang?
Yes, I've met him.
Do you know what his expertise is?
I can't, no, I don't. I can't clearly
Okay.
articulate his expertise, but I know, that's not going to say that. I can't articulate his expertise.
Okay, would you dispute that he is a professor of law at the University of Hawaii, Richardson School of Law?
My understanding, he is a professor there and he works at that particular school.
And he has been there for 34 years. And he teaches the subject of the legality of the state of Hawaii, the power of a resolution by the United States government to annex a foreign country to be not lawful. Do you know that to be true?
I don't know that.
Okay. Again, we're just making a record here. And so do you recall several weeks ago when we were going through our scheduling that I had tried to pin down an exact date from my witnesses, which were two, which was Michael Lee and Professor William Chang, to come, and we agreed by stipulation that it would be on the 23rd of January, 2017. Do you recall that?
Yes, I recall that.
Okay, so what I'm trying to allude to is that there has been fair notice that these two witnesses were coming on, that it was my day to testify. My documents and submission has been into the documents file since October. And so when I'm told that, or I seen the video of Mr. Mano claiming that she didn't have enough time to read it, I look at myself and go, didn't she pull that on me? That I had enough time to read something? And yet she's had months and suddenly she doesn't have enough time to read my stuff. And therefore she thought it was important to deny Mr. Chang the right to testify in this case.
So I'm gonna object on a running objection, I guess,
Okay?
on this matter. I think the appropriate place and time for this and to bring this up is probably at the end of the day under in business. I think you're trying to insert this into this cross-examining, and I think it's inappropriate. Because I'm not saying that the issue that you have at hand is inappropriate. I think you have a position here.
Professor,
But-
if
and
you don't mind, what is your objection?
My objection is that it's not relevant to this my cross. I mean, it's not relevant to my
To
testimony.
your testimony. Okay.
It's further outside the scope of your written direct.
Yes. Way outside. But that's my objection.
Mr. Fergerstrom?
No, I'm going to accept that to be okay.
Sustained.
Boy, that was fast, huh? Wish you could read that fast. And so, just to make note, you have in your possession right now, I hand-delivered it to you this morning, my papers regarding the demand for written explanation, as well as a demand for the production of documents. I'm speaking to you, Mr. Mano.
If you have a question for this witness, please continue.
I don't have a question for this
Then you're
witness
done.
at this time. No,
If
I'm
you
not
have no
done.
further questions,
I have further questions.
if you have further questions of this witness, please go forward. Otherwise,
Thank
we
you,
need
I
to
will.
move on.
Thank you, I will.
Otherwise, we're going to move on to another
Are you going to move?
questioner.
You're going to do what? You're forgetting yourself. You are just a hearings officer. That's all you are.
I think it's very.
And I am a recognized party to this case. And I have a right to be heard just as much as anybody else does.
Ms. Aluli?
Your Honor, I would respectfully ask Mr. Fergerstrom to allow us to proceed. Mr. Flores has to go to work tomorrow. We all are sitting here, and I I know I'm not supposed to object, but it's improper. This is very improper that we.
Okay, thank you. I'll accept that and I'll move on. Thank you very much. I've made my point. And so in summary of what I was talking about, that in the CDA, it refers to an area known as Kaohi Mauka, an Aupua known as Kaohi Mauka, which you have testified to that you have never heard of such an Aupua called Kaohi Mauka, but you have heard of one called Kaohi Hamakua.
Yes, I'm familiar with the ahupua of Kaohe within the moku of Hamakua.
Thank you. There will be no more questions from me. Thank
Ms.
you very
Kihoi?
much.
Thank you.
Get ready. I'm coming. Excuse me.
Aloha, Professor Flores.
Aloha.
Mehana Kihoi. First of all, I just want to say mahalo for your tireless efforts and work, your continued work, and for everything you do for our people and our, Just to clarify, or point of clarification, when Mr. Fergerstrom spoke about what had happened to your family on the mountain as a spiritual attack, would you define what happened as a spiritual attack?
I wouldn't necessarily frame it as an attack. It was a spiritual encounter as a consequence of what had happened there. And what was there was extremely disturbed and angry. And so, being we were there, that entity came to us.
Thank you. And just another point of clarification. In that event, did your family take responsibility for what had been done to the mountain at that point? Or were you asking forgiveness on behalf of those who had damaged the mountain?
We at no part took responsibility for actions of someone else because everyone's accountable for their actions. What we could do was ask forgiveness on behalf of those who did the actions.
Okay. Thank you for that clarification. As an educator for 30 years, do you consider education important?
Yes,
And as a professor, do you consider higher education important?
yes.
What is your perspective as an educator and professor of the TMT project's proposal of awarding funds for educational activities and scholarships in exchange for building this telescope?
My perspective on the matter as an educator and a professor for 30 years as an educator, and particularly education in the Hawaiian studies programs and education with Hawaiian students as well, that this is a blatant community bribe. And when I say a bribe, they're offering money to destroy. And when I say it's a bribe, there's strings attached to it. And you would think of when this idea to give money, when they contrived this particular idea that they're going to give money so they could end as a result of what the damages and cultural impacts and everything else, the natural impacts. It's a great concept they came with, in a way. Here's the money from this project. We're going to give it to schools and so forth. And we're going to give it for scholarships. And so you're taking the money. It's like blood money. It's like blood money. You're taking it's a community bribe. There's strings attached to it. What's even more, when you look at it even more closely, when you talk about the scholarships, so here's the project. TIO is giving the money to a person, the in-between person, to support this project, scholarship money. Then the scholarship money, in most cases, is going to the UH. They've come up with a great scheme to pass money through, and it ends up back to the applicant. So from the developer of the project to the applicant, not all the money is going to the applicant, only the certain monies that are in scholarships, but the majority of the students it's proposed, not proposed, but many of these students are going to the University of Hawaii system. They're paying the applicant in a way. It's a pass-through of money. And in the middle stands the community, the schools, and the individuals. It's a community bribe. Take the money, support the project. We've seen this type of We've seen this with many other developments in these islands. I've seen this on many other projects that have come through. How money is used in a community to buy support for a project when they know it's adverse and when they know the impacts are significant. And that's my perspective on it.
Thank you. And so, if the TMT was not built on Mauna Kea, are there other sources of funds for educational activities and scholarships?
Of course there is. And when you look at, so it's as if the TMT is not built over us, we don't have any money. Let's look at who the TMT really are. The TMT, our partners are already on the mountain. Caltech, University of California, Japan, and Canada, they already have interest and partnerships in some of the existing telescopes on the mountain. So why not, if the team, not just a why not, if the TMT wasn't built and they felt it was so important that the community should have this money and should have these scholarships, then why not have the existing telescopes put in that money? We have 13 telescopes up there. You eliminate the UH telescopes, you'll get, if everybody paid $1 million a year, you get somewhere between $9 and $10 million. That's where you get your money from. You don't need a new telescope, $1 million a year, to bribe us. Just have the existing telescopes fund these programs. If the astronomy community and the existing telescopes and existing partners felt that this was so important, then they should be funding it to the extent beyond $1 million with no strings attached, because they're already there. It's as simple as that.
Okay. Thank you. I think that's all the questions that I have.
Thank you,
Mahalo.
Ms. Kihoi.
Thank you.
Mr. Chu. All right, thank you. Mr. Sinkin.
Good afternoon, Mr. Flores,
Aloha.
or Professor Flores, I should say. Actually, the first thing I wanted to do was to clarify some interrelationships here between some of the things you've been discussing. You have discussed FLU-2. Which appears in your testimony.
Yes.
Can you, oh yes, okay, it's on page 8 of your testimony. So FLU-2 talks about an updated or talks about updated inventories of cultural and natural resources. Would there be any relationship between that obligation and the Kapakai obligation to do an inventory of cultural and natural resources?
I'm saying yes, but the Kapakai independent analysis would be done by BLNR or DLNR. And so that information could, yes, be used to update this and what's supposed to be done, this particular land use zones map and inventory.
So the two inventories would be similar in approach and topics that he covered and that kind of thing.
Yes.
Okay. And you discussed the University of Hawaii completing an EIS for the proposed new general lease that would extend beyond 2033. And you've made the argument that they're putting the cart before the horse again, in that they should do the EIS first before deciding whether to grant the permit to the TMT. I'm wondering, do you believe that granting the permit sought for the TMT would actually compromise the objectivity of the BLNR regarding approval of a new general lease? Because with TMT already built and with a 50-year lifetime, wouldn't TMT have a pretty strong argument that the general lease should be renewed to protect TMT?
I agree with that end statement.
And you also discussed the requirement to update the comprehensive management plan every 5 years. And just I wanted to check if I remember correctly that somehow that update was delegated to the Office of Mauna Kea Management, and that in her testimony, the executive director of the Office of Mauna Kea Management, Stephanie Nagata, said that she told the Office of Mauna Kea Management Board that there was no need to update the CMP with a new 5-year analysis. Do you remember that?
I remember that testimony, and well, unfortunately, Ms. Nagata does not have the authority to make those decisions. If anyone is going to determine whether a major 5-year review plan or revision is needed or not needed, that would have to come from the Board of Land and Natural Resources, which approve the CMP and the subplans as such.
So would it be your position that the BLNR, DLNR cannot delegate the update responsibility to the Office of Mauna Kea Management?
No, they are able to delegate delegate that to them. What I'm saying, the delegation to them does not give them the authority to make the determination whether they have to do one or not. It's already prescribed in the CMP that it has to be done, a 5-year major review plan. So they don't have the authority. Office of Mauna Kea Management, University of Hawaii at Hilo, University of Hawaii has no authority to say that they don't have to do it. If that decision was to be made, that would have to be done at the board level, because it's the board that approved the CMP with those management action items in there.
And on page 7 of your testimony, in the chart at the bottom of page 7, there's item CR-2, which is described as support application for designation of the summit region of Mauna Kea as a traditional cultural property per the National Historic Preservation Act of 1966 as amended 16 USC 470 et sec in consultation with the larger community. Are there any geographic boundaries that you're aware of that have been determined as to what part of Mauna Kea would be so designated if such a designation was sought?
Based upon my research into this matter, it's believed that the designation of Mauna Kea as a traditional cultural property would include the mountain in its entirety of the summit, but what's not clear as to where the bottom boundary would go. There are TCPs within that, but based upon the State Historic Preservation Division records and even the archaeological inventory surveys, they all say that the entire mountain, at least down to what's considered the Mauna Kea Science Reserve, is eligible to be designated as what we call a TCP.
A traditional cultural property.
Yes.
And would that include the TMT site?
Yes.
So if this item CR2 had actually been completed, let's say before the application by TMT for a permit, would such a designation have any implications for the completeness or terms of the CDUA?
Based upon my research and understanding in regards to the eligibility criteria for TCP,
Let me rephrase the question a little. On that CR2 item, it says over on the right-hand side where it's to indicate whether there's applicability to the TMP project, it says not applicable, as if a determination that there was a traditional cultural property on the summit region of Mauna Kea would have no impact at all on the TMT. Would you agree that it's not applicable?
I don't believe this. I believe what's written as being not applicable. I believe this application regarding the TCP is directly applicable. This application regarding the TCP is directly applicable what's happening in this particular area.
Can you elaborate on that a little as to why you consider it applicable? Directly applicable, I think was your term.
So regardless if it actually receives the TCP designation, it's still eligible to be a TCP or traditional property. So whether it has the designation or not, as long as it's eligible, then any impacts on traditional cultural property has to be fully assessed and analyzed as part of this, whatever project comes later, in this case, the TCP project. If you go through this
And on page 8, item P3 refers to obtaining statutory rulemaking authority from the legislature authorizing the University of Hawaii to adopt administrative rules pursuant to Chapter 91 and implement and enforce management actions. Did the University of Hawaii obtain statutory rulemaking authority from the legislature to adopt administrative rules to in management actions? Has such been adopted?
not only has it been adopted, but there hasn't been any consultation within either Hawaiian culture practitioners who are associated with Mauna Kea. So how those rules would impact them. Let's say with in these 2 years, so I've seen these being proposed years span.
And so during that 2-year span, to your knowledge, there's been no consultation with traditional practitioners on the appropriateness of the rules.
That I'm not sure
Okay.
to what extent that has occurred or not.
Okay.
So I'm going to say I'm not sure.
On page 20 of your testimony, you quote from the TMT Final Environmental Impact Statement, this phrase that we've heard repeatedly in these proceedings about the past and present actions on cultural, archaeological, and historic resources is substantial, significant, and adverse, and that those impacts would continue to be substantial, significant, and adverse with the consideration of the TMT project and other reasonably foreseeable future actions. Is it your position that once the impacts of the astronomy industry on the cultural and ecological resources on the Mauna reached substantial, adverse, and significant, all future development of large structures on the Mauna should have stopped?
Yes.
And on page 20, you also state that the greatest obstacle in the protection of sacred places is a lack of understanding of why those places are significant and so special.
Yes.
Were you present when Michael Lee testified?
Yes.
Does his information about astronomical uses of Mauna Kea by traditional astronomers appear anywhere in the CDUA?
No.
Did you hear him testify that he offered to brief telescope proponents and they did not take him up on his offer?
Yes.
Do you believe the responsibility rests with such traditional practitioners to pursue the telescope proponents with traditional information? Or was it the fundamental responsibility of the telescope proponents to seek out Mr. Lee's information?
I think Mr. Lee made it clear that he offered this information to the bodies to be, I believe, at the BNR and others who were there. But my recollection is that he stated that he hasn't since been contacted or consulted regarding those cultural practices.
My question actually moved to the next step. Do you think that he has fulfilled his obligation by offering to brief them, and that the responsibility for them not including his information is on the proponents of the telescope?
So, I mean, proponents of the telescope is a broad category.
The people he offered to brief.
So, the ones who should take him up in his offer in the not most immediately would be DLNR and BLNR through DLNR, because they have to do the kapa'akai, and they have to do the kapa'akai independent assessment of cultural practitioners having to do with Mauna Kea. So if they have to do this assessment, which they haven't done, is clearly, then these are the people that they should be consulting with and receiving this information so they can make appropriate determinations when projects or permits such as this come before them regarding Mauna Kea.
So if you were creating the list of people to be consulted for a kapa'akai analysis, Mr. Lee would be on your list.
He would be on the list, especially since he's offered to be to be consulted.
Thank you. And you were asked about some emergency rules that were adopted by BLNR, and the hearing officer expressed her lack of knowledge about that particular incident. So I wanted to just flesh that out a little bit. Do you recall that on July 10th, 2015, the Board of Land and Natural Resources issued rules which excluded all persons from a defined restricted area between the hours of 10 p.m. and 4 a.m.?
I recall those rules, but I don't recall if that's the actual date or so, but I do recall the rules.
And that there was an exception to the rules for astronomers or employees of a University of Hawaii facility, that they could go up the mountain?
Yes.
And that there was a prohibition on the possession of sleeping bags, camping stoves, or propane burners?
That was part of the emergency rules, yes.
And the restricted area that they defined included the Mauna Kea access road and 1 mile on either side of that road?
I'm going to say yes, but however, what people refer to as the Mauna Kea access road, the question at point was, is that really called the Mauna Kea access road? But on their maps,
That's what they call it.
that's what they refer to it as.
Would you call it the John Burns Road, or what would you call it?
My understanding, John Burns Road is the one that's further up that was created. It's not the one that's on the paved road that comes up from the junction of the Daniel Inouye Highway, and it goes up to the Halepohaku. But I don't recall the exact name of that road, but
Okay.
there seems to be, based upon my understanding in this case, that there were there's questions about what is the actual name of these roads, and to what extent these emergency rules would be applicable.
Assuming for the moment that everybody was referring to the road that goes up to the summit, was the impact of these rules to basically exclude spiritual practitioners who practiced at night because you couldn't go up there between 10 p.m. and 4 a.m.?
I don't know if it specifically excluded them, but it did exclude them as a result of these rules.
The effect of the rules was to exclude them.
Right.
And then Circuit Judge Ronald Ibarra invalidated the rules based on BLNR not following the law and how they adopted the rules. You remember that?
Yes.
And just to clear up the question of what authority was present when they were grading the road and building the pad and doing all those things for the initial ceremony, I think there's been testimony in this hearing that they got a permit to enter. Are you familiar with that?
That exact so-called reference I'm not familiar with, other than the permit that was issued under in CDUP HA 3568.
So they had the permit, the actual permit had been granted to them, and they got permission to enter is what I remember. But if that's not clear, that's all right. We can move on.
Yeah, I'm not clear on what was stated as such, whether that's true or not.
On page 18 of your written direct testimony pertaining to adverse impacts upon the sacred piko and resources of Mauna Kea, what does the term piko refer to in your testimony?
So there's many definitions of piko. If you go in the dictionary, there's 8 different definitions of the word piko, spelled P-I-K-O. But a piko, in one context, as defined in the Hawaiian dictionary, is a summit. It's referred to as the piko, the very summit of mountains that referred to as piko. But if you go further in the CMP in their cultural anchor introduction to the CMP, it goes further on discussing how the piko, with it, like the comparison to the piko of a person, there's a piko on top of your head, connection to the past generations. There's a piko where most people are familiar with, the umbilical cord, your navel. That's a connection to your present generations. And the other piko is your genitalia, which is a connection to your future generations. So there's this connection. There's a concept of triple piko in Hawaiian traditions and accounts that describes these piko. It goes further on to describe, and so from my understanding, as I'm going to state this from my understanding, that the piko on top of the mountain, besides it being a piko, literally being a piko, the piko on top of the summit of the mountain is like the piko on top of our head. And it's in that context that the head of a person in Hawaiian culture and tradition is sacred. These three piko are very sacred and significant, and just like the piko on top of Mauna Wakea.
And based upon your expertise, your knowledge, your research, are there written accounts describing Mauna Kea as being sacred other than those that we've seen in the record here to date?
Yes, there's several accounts. I mean, it's in the UH's documents. So when Mr. Coleman came here, who had no background or expertise in Hawaiian traditions and culture, came up with to say there's no accounts of being sacred. All he had to do was look in UH's own documents. It's right in their documents. It's in the FEIS document in the preface of it. It's in the CMP document. It's throughout the documents. They cite sources of why the mountain is considered sacred. There's no dispute as it being sacred. These accounts have already been written, and a number of these accounts go back, are old accounts as well. And so it's well documented in the reports, in UH's own reports, in their own documents, as to why is Mauna Kea considered sacred.
And are there also many references in different documents to Mauna Kea as a burial ground?
And there are references to Mauna Kea as being a burial ground. You have to understand, when we say a burial ground, the typical burial ground that some people might think of is that you're going to find like a cemetery and people buried here and there, and there are examples of that. But you also have to understand, and this is from family accounts, that many ancestors' bones are in the dust on the mountain, because so many of our ancestors, not all of them, of course, but some of them went up there when they knew their time was transitioning and when the time was passing. They went up to this realm. And as such, you won't necessarily find the remains and bones. They're in the dust of the land.
So if we went out, the highway outside of Hilo to the cemetery there and removed all of the markers and rocks and everything in that cemetery, so all you saw was barren land, would you still consider that land to be a cemetery because there's bones in the ground?
Yes.
And you have an exhibit B02W as a photograph. Can you display that? Can you tell us about this photograph and identify it for us?
So at the time we were going through the first contested case hearing, there are many things that have occurred on the mountain and during this whole path that we've been on. And what is explained to us, the significance of this mountain. When I say it's a pico, it's more than just being a pico in a context. In the other context, it's also in essence a portal where life forces come through this mountain and energies also leave through this mountain. What you see here in this photograph, and it was taken from Waimea by Kehaulani Marshall in March 4th of 2011, of this event that's happening. And so in this dark outline in this figure is the outline of the mountain. On this particular day, the entire part of the mountain above was clouded over, except for this one opening in a portal that was above it. And so when we ask for Ike Kupuna, ancestral knowledge and insight, what was shared with us is that what we see in this picture is what was happening at that time. There was these energies that were flowing through from above. And when I say above, whether you believe in a concept of a supreme being, a creator, a God, what Hawaiians also refer to as Keakua, these were life force energies coming from the creator, coming through this portal here. And what they allowed us to see, because it's not like this all the time when these life force energies are coming in and out of the top of this mountain. Many times you can't even see it. Perhaps there are people who can feel it, but you can't see it. What they gave us, when I say us, the people who were able to witness this, those were from Waimea, Hilo, and Kona that day, was what was happening on the mountain. They gave us a physical picture that we could visually see of what's happening. The entire mountain is covered above with clouds, except for this small opening above it. And that was what was happening that day. And that's how it was explained to us through Ike Kupuna.
So this was a physical manifestation of a spiritual event.
This is a physical manifestation. I'm not calling it a spiritual event. I'm just talking about a event that's happening on top of the mountain.
And just from your general knowledge of science, would you relate this to a different cosmology that deals with electromagnetic fields?
Yes, so we're talking about energies, and it includes electromagnetic fields. And so from the Ike Kupuna, from ancestral insight, from what's happening on top of the mountain, and we're not only talking about this particular mountain, we're talking about other significant mountains like this throughout the world, play a role in keeping the earth in balance. And as was explained to us, these energies that come in and out of these mountains, if you could think of it as like an acupuncture points on the earth, they keep things in balance. And there's a natural energy lines that run on the earth, and many of them go up to these mountains. So without going too far out for people who might not even understand or even accept what I'm saying, is that in the science world, we can measure electromagnetic fields. So as you explained to us what's happening on top of the mountain, is that with all these observatories that have been built up there, they're causing a disturbance to the natural energy field of this mountain. and it's put things out of balance. And that there's also an electrical magnetic, the electrical current that comes up on those from Helco, from the substation at Halipuaku. It comes up the mountain. It comes in an underground conduit, comes up to the mountain to feed all these telescopes. If you go to the summit, you'll hear the AC and other equipment running to keep these telescopes cool during the day. All this electrical current that's coming up here, this man-made current, is interfering with and is disturbing the natural electrical magnetic field of this mountain. I can't explain it much further, is that
That's fine.
Things are out of balance on the mountain at this time.
Right. Are there written accounts describing how Mauna Kea's sacred quality would be impacted by the proposed TMT project?
I know it's written in the okay, so if you go into the TMT, the FEIS, page 329, in my written direct testimony, it's on page 20. It states right there, the project has the potential to impact the spiritual and sacred quality of Mauna Kea. It's in the EIS. Yet,
Thank you.
how to address this is not addressed or in any way in the CDUA.
So the CDUA does not actually get into discussing what that potential is. Is that what you're saying? The statement you quoted from the FEIS is that the project has the potential to impact the spiritual and sacred quality of Mauna Kea. In the CDUA, where is the discussion of how that potential might be realized?
Right. And more so, how do you mitigate that?
But I'm actually, that was a question I asked, but it didn't appear as a question. Where in the CDUA or is there in the CDUA any discussion of how that potential to impact the spiritual and sacred quality of Mauna Kea would manifest itself?
So I don't see in how the CDUA adequately addresses that.
On page 22 of your written direct testimony, pertaining to adverse impacts upon ancestral Akua, Kupua, and Kupuna. What does the term Akua refer to in your testimony?
So of course the word Akua in the general context can refer to gods, goddesses, deities, divas, natural spirits, divine beings, natural forces. But also, Akua, Keakua is also referred to as God, the creator, the supreme being. Okay? And so, in the context as it's written, it's inclusive of all. And from our understanding of how things are, is that I could say myself, there's a belief and understanding. It's more than a belief, it's a knowing and an understanding that there's a supreme being, a creator, a God, Keakua, that overlooks everything in this universes that we live in this planet that we live on. Okay. And so the creator has placed certain divine beings and guardians in certain places on this earth to keep things in balance. And on Mauna Kea, there are those divine beings that are situated, whether it's at Lake Waiau or other parts on the northern plateau or other areas that serve in that capacity. So the Creator, Keakua, put these, we refer to Akua or others, in these capacities to serve as guardians as such on this land, on this mountain, as well as other places in these islands.
And just as a general proposition, are many of the spiritual practices on the mountain intended to help maintain the balance on the earth?
Not just on the mountain, but places around the world, it is to maintain balance. And that's why the reference to Vau Akua, the realm of Akua, it was noted as such, so that when you go into these places, there's people go into these places, but not on a usual basis. They have a purpose and function. But when you go into these places, you know you're going to these special and sacred places that you tread lightly, you walk softly, you walk respectfully, because you're entering an area that needs to be maintained in a certain pristine and special way in order that things can be in harmony and balance with man and the place that they live, and all those things connected to it.
And what does the term kupua refer to in your testimony?
So kupua, spelled K-U-P-U-A, are other beings, and I don't want to say beings in a way, but there are other entities, there are other, and you look at the dictionary, it says supernatural beings, but it's more than that. It's not like a supernatural. They are in that way, but the best. So our ancestors, a kupuna, called them kupua. There are these other beings that are there. They're not human. There are other beings that are like that, and the comparison to a kupua who is on the mountain is Mo'oinania, who serves as a guardian at Lake Waiau.
Right. And what does the term kupuna refer to in your testimony?
And so kupuna spelled K-U-P-U-N-A, as noted, refers to ancestors. And the ancestors, as such, are ancestors who are in spirit in some cases. And those ancestors could be those from early times. Some of these ancestors are ali'i. Some of these ancestors are not. There are many kupuna, ancestral ancestors that are also serve different roles and purposes on the mountain, and others who are not necessarily serving a purpose, but are there on the mountain as well.
All right, so when you're talking about all of these things, and you sort of said in the middle of it there may be people that don't accept what you're saying, how would you respond to individuals with a mindset or a lack of understanding who might choose to dismiss the existence of Akua, Kupua, and Kupuna, or dismiss them as mythological folklore or far-fetched?
I'm not here to try to convince anyone on anything that we do. I can only share what we've experienced. But it would be very narrow-minded for people to believe that the human physical form is the only form of life here on this earth. There's many things beyond the physical. And I can say personally, we've encountered many things from the spirit realm in many different ways. And that our ancestors understood this very clear. That when we talk about Akua, our Akua in a context are the natural elements. The natural elements around us That's why our kupuna, our ancestors, gave them names. So it's not just the rain or the snow or the ocean and the waters. These elemental forms were the akua of our people. And it's not just elements. These elements have a consciousness. And when I say a consciousness, they have the ability to interact with us as humans. They have an ability to listen and receive what we have to offer in a chant or a song, and they have the ability to respond back. The best way most people might be familiar with is tutupele. It is many accounts of family accounts and stories that's also been written how families and ali'i interacted with Pele. From the times when Pele was coming down from Hualalai and was going to take the fish ponds of Kamehameha, that he, as his kahuna, he went to advise his kahuna, can you go and ask Pele to intercede for me? And the kahuna told Kamehameha, no, you are the ali'i. Only you can go there. And so Kamehameha went down, and he went and offered his hair and other items as a requesting Pele, please do not take my sacred fish ponds of Kiholo. And the other things as Pele was coming down. And she stopped. She stopped. The traditions tell us she heard Kamehameha and she stopped her flow. Now this is before the end of the kapu in 1819, but this still occurred in the late 1800s when a lava flow was coming down and threatening Hilo town. The people, our people, they went to Princess Ruth Kealoha, and they asked her. She was the highest ranking ali'i of the. She was not the highest, but she was an ali'i of that time, still connected to these traditions. And they asked Princess Luka, "Can you come and ask Pele to spare Hilo?" And she did. She does. There's written accounts of it. She goes up there, and with a red handkerchief and other things she offered. Pele heard. Pele listened to what she said and the requests that she made. Pele stopped and spared Hilo town. That is what we're talking about, is the ability to interact with these elements. The elements hear us, respond to us. That is why our kupuna gave the elements names. That's why they gave the elements on the mountain of the snow and the hail and the things. That's why they call her Poliahu. They're able to call her name, they're able to chant to her, and she will respond. Same with Pele. So, to narrow it down, in this part here, we're talking about these aspects. These are all under the umbrella of a supreme God, being, creator. And so when our people came to these islands on their canoes, they didn't necessarily bring these gods with them. Because these caretakers, the elements, were already here. What they brought with them was the understanding, how to interact with them, how to acknowledge them, how to be in harmony with them. That is the knowledge, that is the insight that our people came on their canoes when they came here. So when they went up to the mountain, there were certain individuals who had the ability to communicate with these elements directly. And that is how our people lived, and that is how we still proceed today. It's about being in lokahi, in balance, in harmony with all things around us. And when you go to the top of this mountain, Mauna Kea, that is how you would conduct yourself, is you're stepping into a temple.
Thank you. Would the proposed TMT construction and development within the environmentally and culturally sensitive landscape of Mauna Kea cause adverse impacts and irreparable harm upon the Akua, the Kupua, and the Kupuna of Mauna Kea?
Yes.
On page 25 of your written direct testimony pertaining to adverse impacts upon Native Hawaiian customary and traditional practices, are these practices connected to cultural sites in the vicinity of the proposed TMT site?
Yes.
And in that very eloquent presentation you just made about how Hawaiians traditionally relate to the natural environment and to other dimensions, is there any significant discussion of all of that in the CDUA?
None at all.
That's all I have, Your Honor.
Thank you, Mr. Sinkin. We should take a short break so everybody can go to the bathroom or whatever. So 10 minutes, please.
You're watching Naleo TV.
Aloha, Kalani.
Aloha, no.
I mean, Professor. Hey, I don't know that. Okay. Man, at work, I was, it was off and on, I could catch some of these things, so, but, you guys covered a lot of ground. Thank you. Thank you and your family. And Mo'o Inania. I just get like about one or two questions, yeah? The tops of our mountain, the pu'u, yeah? I always go back to that, I don't know why, but when you remove those, for me, in my teaching, the very top, when you remove the top, you're removing antenna. The receivers, of different things that come to us, each pu'u represents certain different representations of balancing and different things that they represent through the teachings of each god or goddess. But the question is, when you, well, can I say them that way? Would you say that by removing our antenna in that thought, the tops of our pu'u, they have actually put the telescopes right where the antenna is supposed to be. So they're receiving all this information and energies and different things like that. Would you say that they're storing the iki ponopono of our kahonua?
Can you repeat the last part of your question? I didn't
Have
quite
they
get-
stolen the ike ponopono of our kahonua
Could you?
by putting telescopes in the place of our antenna?
I got that part, but just the last part of the sentence. Can you repeat?
The knowledge of the balancing of our honua, our earth.
Yes. Is what? I mean, I just didn't catch the last part of what your question.
By putting the telescopes in the place of the antenna.
Yes.
Yeah.
I got that part, the last part. What was the follow-up part of that question? I just didn't hear
Or
it.
have they stolen Ike, the knowledge, and the money that comes from the head?
Is the word, you said stolen?
Yeah. Or maybe I shouldn't use that word, whatever that word is, absorb or use in not quite good manner.
Well, I don't necessarily if the word stolen, but it's drastically disrupted and disturbed that antenna that as you referenced to on the top of the mountain. Or is that not the,
No,
what you're in? The
yeah, but
question
you
you're
go,
applying.
just as receiving, another thing about receivers in there.
Right.
It collects it.
Right. So, as previously mentioned, is that the physical construction that occurred and has occurred with the existing 13 telescopes on the mountain, not just any particular place on the mountain, but the very, very top of the summit, at the very top of that pico, and with the electromagnetic disturbances of this huge electrical currents being brought up to that pico, it has drastically disturbed and disrupted the reference to what you're saying is to where these energies and other life form forces come into this earth through this particular pico. It has drastically disturbed that.
I'm glad that we're going to, how would we, I guess we were doing that, bring that information to Bill and R so they can make the right decisions here. So anyway, remember in the beginning of the contested case hearings, and we were looking for who was liable for all this, well, for me, desecration and destruction, not only in Hawaii, but on a global scale. And that it took us about 4 years to find that. So in nowadays, we found out it's BLNR or DLNR, because they are our protectors. So before I think that's all. Thank you.
Okay, mahalo.
Thank you. Mr. Vicente?
Dwight Vicente. Good afternoon.
Aloha.
I only got a couple of questions. Are you familiar with the Northwest Ordinance of 1787?
You know, honestly, I'm not familiar with it, but I hope that at some point in time after this, I would like to sit down with you and understand it a bit more clearly.
Are you familiar with the Reciprocity Treaty of 1875 between King Kalakaua and the United States?
I thought it was 1876. So whatever that particular year, I am familiar with that reciprocity treaty.
Are you aware of the amendment to that 1875 done in 1887?
And I'm not familiar with that specific amendment.
That amendment allowed the U.S. Navy to be stationed at Pearl River, which we know as Pearl Harbor today. Have you been to Oahu lately?
Yes.
Did you notice that the U.S. Navy is still there?
Yes.
That's all the questions I have. I'd like to reserve the right to raise the federal questions in D.C. federal court based on Article 4, Section 3, Clause 2 of the U.S. Constitution. Thank you.
You're welcome. Mrs. Freitas?
Aloha. Aloha.
Wait, aloha.
Cindy Freitas. So isn't it true to say that the UH Office of Mauna Kea carries out UH management responsibilities for the Mauna Kea Science Reserve, Halepohaku, and the Summit Access Road?
The Office of Mauna Kea Management?
Yes.
Yes.
So wouldn't it be fair to say, despite the office in charge to protect Mauna Kea culture and natural resources and to help ensure public health and safety on the mountain, the office authority to do so has not yet been established in administration rule?
Yes.
So to date, as of today, there's no rules for Mauna Kea have been adopted by UH, even though the CMP was approved by BLNR in 2009.
Yes.
The UH office also lacks enforcement authorities to protect the mountain resources from the impact of public and commercial activities, even though it is responsible for the resources.
Yes.
Being said, the UH did not adopt administration rules for the Mauna Kea land, so UH cannot fulfill its stewardship responsibility. Is that correct?
Well, it can fulfill its stewardship abilities to a certain extent, but to its fullest extent, to protect the natural and cultural resources, they don't have that ability to do based upon my assessment of the Office of Mauna Kea Management and the CMP and the subplans as such.
Thank you. From your knowledge, administration rulemaking is one of the methods by which state agencies carry out at their tasks. Is that correct?
Yes.
Isn't it fair to say that the purpose of rule is to implement laws such as these relating to Mauna Kea land and to establish operating procedures for the state agencies?
You're gonna have to say that. Repeat the
okay.
question again. I didn't quite get the whole question.
Isn't it fair the purpose of the rule is to implement laws such as these relating to Mauna Kea land and to establish operating procedures for the state agencies?
Well, I'm not sure if it's for the state agencies. Some of these rules are more specific for the University of Hawaii, through the University of Hawaii Hilo, and as well as the Office of Mauna Kea Management. So not necessarily for other state agencies, but for the body of the agency as the University of Hawaii.
Okay, it's internal.
Yes.
Okay. I'm gonna lay down this foundation. Act 132, Session Law of Hawaii 2009, clarify UH authority to manage its leased Mauna Kea land by granting UH express authority to adopt rules relating to the public and the commercial activities pertaining Isn't it true to say the administration rule currently in effect for the natural and the culture area reserve lands managed by the Department of Land and Natural Resources do not apply to the Mauna Kea lands?
Well, I'm gonna say no to that. I mean, those lands are Mauna Kea lands, so there are rules for the natural area reserve, and those lands are on Mauna Kea, so they do apply to the Mauna Kea lands, but not necessarily all the lands are Mauna Kea.
Okay. In addition to granting UH express authority to adopt relating to 2009 public and commercial activities, Act 132 Session Laws of Hawaii, 2009, also the authority UH to indicate enforcement proceedings against individual who violates these rules and to assess fines up to $10,000 per offense. But isn't it true to say that UH doesn't have an administration rule in place for that?
Yes, they don't have administrative rules in place.
So therefore, UH must rely on DLNR's Division of Conservation and Resource Enforcement, which is adult care officers and county police, to carry out this function.
Yes.
Isn't it fair to say that UH has? Oh. Now we're going back to Stephanie Nagata in a cross-examination, in a cross-testifying. She had stated to some of the persons who's crossing that Ahu Okoko was accidentally taken down by a machine, some kind of machine.
And the question?
Then she stated, she recanted her testimony when I cross-examined her, that the Ahu that is located at the 3.5 and the 3 mile marker, that it was intentionally taken down. Is that correct? I mean, from the testimony I got.
I'm not clear on exactly the wording as far as that.
Okay.
Intentional. I'm not sure. That's all I can say.
Okay, let me rephrase something. Did a Mauna Kea support service employee take down the Ahu on mile marker 3.5 and 3 on the summit of Mauna Kea?
Based upon in Ms. Nagata's testimony, that's what was stated.
Okay. Are you aware of any complaints made by the petitioner on that Ahu?
What petitioner is he referring to?
I mean, sorry. Let me rephrase.
I'm going to answer the question. I don't know.
Okay. Are you aware of any protectors doing a complaint on the Ahu at 3.5 and 3 mile marker on the summit?
My understanding, there was a complaint filed regarding that incident.
So are you aware of that complaint? The doc number HA-16-204 was issued September 2015 on the Ahu?
No, I'm not familiar with that document.
I have no more question, but I reserve the right to issue the document when it becomes available
To issue the document?
as my exhibit.
Oh,
Yes, right now we're trying to retrieve that document.
okay.
Thank you.
Mr.
No
Lui
more
Kwan?
question.
Thank you, Judge Amano. Hello, Mr. Flores.
Aloha.
I'm Tim Lui Kwan. I'm one of the attorneys for the University of Hawaii, and I've a few questions for you. In your oral summary, you testify that you believe that you qualify as an expert in Native Hawaiian cultural practice and tradition due to your genealogical connections, among other things. Is that correct?
Yes.
Are you from the island of Hawaii? Were you born here?
No.
Where are you from?
You mean from as far as where I was born?
Where were you born?
Born in Honolulu, Oahu.
Okay, in previous testimony, I think you referred to your family's kuleana alongside alongside Halava Stream. Is that correct?
And some of my family is from the area of Halava on Oahu, yes.
So, but you're not from, you're from Halava as well, too?
I have family connections to Halava on Oahu, yes.
So where in Oahu are you from? Where you raised?
I have a flashback to my childhood. Raised in apartments in Kalihi. Later on in Kaneohe. Later out in Waipahu. And between there, with the family's lands in Halava and in Makaha Valley. Or not Makaha Valley, but Makaha. Not in the valley, but the area of Makaha.
And did your members of your family teach you traditions and customary practices in those areas?
Yes.
But those were practices and customs specific to that particular area, correct?
No.
So did any of them apply to the island of Hawaii?
Yes.
So at what point did you begin to exercise cultural practices on Mauna Kea or related to Mauna Kea?
I would say somewhere is between the late 70s and early 1980s.
Could you describe some of the practices you began exercising in the 70s?
Is the connection and interaction with the elements on Mauna Kea.
So you think in the 70s sometime. When did you move to the island of Hawaii?
Probably around 1978.
And have you been a resident of the island of Hawaii since 1978?
No.
So can you walk me through from 1978 to whatever year you were a resident here?
I don't see the relevance, but I can walk you through it. But from probably to 82, and then I moved to Kauai for a job there, and I was a job there for a number of years. And then I left Kauai probably around in 2000, and I've been here ever since.
So when you lived in Kauai, you said you took a job in Kauai?
Yes.
Was it a teaching job?
Yes.
Where were you employed?
I was employed with the Department of Education, Kauai District, as a Hawaiian Studies resource teacher, and I used to work with the Kupuna program on the island of Kauai.
That was starting in 1982.
It's either 82 or 83.
Okay. And you held on to the same job until 2000?
I think the answers you're looking for is in my CV, but I'll entertain your questions here. And to give you specifics, I was working on Kauai from 1983 to 1993 as a Hawaiian Studies resource teacher. And then I was working, I think the year 2000, I was here on this island here working in various different programs.
Okay, thank you. So between 1993 and 2000, where were you living?
In 1993?
You said you were employed as a Hawaiian resource.
Yeah, I was living on an island of Kauai.
So between 1993 and the year, you said you moved to the island of Hawaii in the year 2000. Is that correct?
I believe it was the year 2000.
Okay, so where were you between 1993 and 2000?
I was on Kauai.
And what were you doing on Kauai?
I was teaching, or I was working in various different programs, such as a Napua Noeau program. And I was working as a lecturer at Kauai Community College and several other programs on Kauai.
So you're working for the Hawaii Community College on Kauai? Or was it the Kauai Community College?
I was working for University of Hawaii at Kauai Community College on Kauai.
Thank you. So you also mentioned earlier today that you believe that you're also an expert. You believe yourself an expert in the areas of the review and assessment of reports on historic properties and cultural practices. Is that correct?
Yes.
Didn't you ask to be recognized as an expert in this area during the first contested case?
I'm not exactly what was the exact terminology, but I'm assuming you have the transcript, so perhaps you could refresh my memory.
Didn't the hearing officer at that time deny your request to be recognized as an expert?
Yes.
Okay, thank you. Mr. Flores, do you have a degree in anthropology?
No.
How about archaeology?
No.
Have you ever worked as an archaeologist?
I've worked along with archaeologists.
You stated earlier that reports of PCSI for the Astronomy Precinct and the Mauna Kea Science Reserves were merely reconnaissance reports or reconnaissance surveys. Is that correct?
Yes.
Do you understand that PCSI actually did archaeological inventory surveys for both the Astronomy Precinct and the Mauna Kea Science Reserve?
That's what I stated in my testimony.
And you also agree that those AIS reports by PCSI were accepted by the State Historic Preservation Division, is that correct?
Yes.
So you mentioned that the reports done by PCSI could not be used for the CDOA because the surveys were not project specific, didn't you?
I didn't say they couldn't be used.
What did you say?
I said in the context of how they're being used. I mean, go back. The context of those particular archaeological inventory surveys was for a general reconnaissance and inventory of what's on the land. But those reports did not address the specifics of the TMT impact upon those sites. because they weren't done for the TMT project. They were done, but for the Office of Mauna Kea Management to get a sense of what's on the land in the astronomy precinct and the Mauna Kea Science Reserve. They were not done specific for the TMT project.
Did you review PCSI's AIS reports?
And which ones?
For both the astronomy precinct and the science reserve.
Are you referring to which drafts? Are you referring to the drafts or the finals?
I'm referring to the drafts that are attached to the EIS.
You're referring to the draft reports that were part of the EIS?
I'm asking you if you have read or reviewed PCSI reports attached to the final EIS.
Yes.
Okay, so didn't the report for the astronomy precinct cover the area where the TMT site was located or proposed?
It covered the area, but it did not cover the TMT site.
Okay, didn't the Mauna Kea Science Reserve AIS report cover the area where the TMT site was proposed or is proposed?
Yes.
Are you familiar with the State Historic Preservation Division rules on archaeological inventory surveys?
And I'm familiar with them, but I don't know them offhand.
Okay, you're familiar with the definition of an archaeological inventory survey?
I don't know the definition offhand.
And if I told you that the purpose of an archaeological inventory survey was to identify and document archaeological historic properties and burial sites in a delineated area, gathering sufficient information to evaluate the significance of historic properties and burial sites, and compiling the information into a written report for review and acceptance by the department. Would you disagree with that definition?
I can't agree or disagree because I'm not sure where you're getting the information from, but I think that what you read to me is from some document, and I don't have no way of verifying what that document is.
Can I show you the rule?
Sure.
So I show you what's been marked on the top. It's not been submitted into evidence or submitted or filed, but it's Chapter 276 HAR, 1376 HAR of the SHPD's rules, and it's entitled, I believe it's entitled Archaeological Inventory Surveys, and there's a definition at the bottom of that first page. Do you see the definition?
Yes.
Can you read the definition? Not out loud, just read it to yourself. And are you sure that this is the definition that you are either familiar or not familiar with?
Well, and I've read the definition as presented here in Chapter 276 on page 1, and that's what I see what it states.
And you said you agreed that the PCSI AIS reports were included in the final EIS, is that correct? Or do you want to check that to be sure?
I don't check it, but I'm not sure if the draft or the final was in the EIS. So that's that's not sure. But there was a report, I'm assuming, that was in the EIS. But what state of the report it was is a question that I have.
Okay, that's fine. Do you or any member of your family, the case Flores case Ohana, file any challenges, any appeal or challenges to the governor's acceptance of the final EIS for the TMT project?
No, because we were not aware of that EIS at the time.
Is Mr. Lloyd case related to any member of the Flores case Ohana?
He's not a member of our Flores case, Ohana, but he is an uncle of my wife.
So
Poor
he's
case.
Poor Case's uncle.
Yes.
Do you know if he was involved in any of the consultation relating to either the EIS or the AIS?
Uncle Lloyd, as we commonly refer to him, may have been because he's a hunter. And perhaps in the capacity as a hunter, perhaps he was consulted. That I'm not sure of or not.
Okay, so during Dr. Abad's testimony 2 weeks ago, she agreed on cross-examination that the EIS was a part of the CDUA. Do you agree with her testimony?
I wasn't here, so I can't agree or not with that testimony of what wasn't present.
Okay, so you weren't informed, otherwise told that she in fact agreed that, that the EIS was part of the CDUA.
I'm not sure. I wasn't here, so I can't agree with that statement or not.
Okay, that's fine. You also testified earlier that the AIS report by Cultural Surveys Hawaii was not introduced or otherwise submitted into this case. Is that correct?
Yes.
But isn't it true that that AIS report is a part of the EIS?
Yes, it's true. The draft AIS done by Hawaii Culture Surveys is part of the environmental impact statement.
So what part is it? Is it attached as Appendix G?
I'm not sure what appendix, but it is an appendix in the.
Okay, thank you. Have you ever prepared a AIS report? That's a yes or no question, Mr. Flores.
I have to think about it because I may have contributed into a
That's
EIS
not my
project,
question.
so
My
I'm not
question is,
sure.
have you prepared an AIS report?
Oh, no, I haven't compared one.
Have you ever prepared a CDUA?
No, I haven't.
Have you ever prepared an EIS?
Isn't that what you asked and answered?
No, I asked you about an AIS, then I asked you about a CDUA.
okay.
Now I'm asking you about an EIS.
Oh, sorry, I just heard what you said. The EIS, no.
Could I fairly describe you as an opponent to the TMT project?
Well, no, because really I'm a protector of the mountain.
Okay, so when did you first become involved as a protector of the mountain?
Was some time in 2000, the end of 2010.
And not before that?
Yes.
Were you not contacted for consultation as a cultural practitioner in 2008?
Not to my recollection.
Is there something I can show you to refresh your recollection?
Sure.
I'll show you page 1, page 93 of the CIA for the TMT Observatory and TMT mid-level facility project. So the CIA, I believe, is a part of A5, and I think it's one of the appendices. It may be H or I. I'm not sure. I think it's H. Is that your name appearing in the table on page 93?
Excuse me, sorry.
Is that your name appearing in the middle of the table on page 93?
Yes.
Do you recall being consulted or asked to consult?
See, I don't recall being asked
Well, you know,
to consult.
Mr. Flores, you may redirect yourself upon
Right.
redirect.
I just
you know.
answered your question. I don't recall being asked to consult.
Okay, that's fine. Thank you. And that's already an exhibit.
Yes.
It's already a part of A5. Let me now show you a series of emails between yourself and Miss Mishala Spearing, a cultural researcher from Cultural Surveys Hawaii.
Thank you.
You recognize the email?
And I mean, I don't recall or recognize the email. That's my answer to the question.
Did you ever turn in a statement?
I
Did you ever turn in a statement consulting on the cultural impact assessment for the TMT project?
I'm not sure.
Okay, thank you. And you don't recall this email?
No, I honestly don't recall this email.
Okay, thank you. You stated in your written direct testimony and in your oral summary and on cross-examination that University of Hawaii, failed to conduct a 5-year review of the CNP in 2014. Is that correct?
Yes.
But didn't Ms. Nagata, in her testimony on December 13th, 2016, at this hearing, state that OMKM did initiate its 5-year review and submitted it in its 2015 annual report to the board?
I don't recall her stating that she submitted a 5-year review.
Okay, and this report is actually attached, or it's actually in our file. It's been filed as, I think, Exhibit 821. Let me show you the minutes of a Mauna Kea Management Board meeting dated November 25th, 2014. I only have one copy, but I'll show it to you, and I'll direct you to pages 5 and 6. And I have it highlighted.
Is this an exhibit you're handing to me to preview or such?
I'm asking you if you've ever seen this document or otherwise have any knowledge of the document.
And can you be more specific as to what document you're referring to?
It is the minutes of the Mauna Kea Management Board meeting of November 25th, 2014, and I would direct you to page 5.
Okay. That was my question earlier.
It hasn't been submitted as exhibit yet. But we will.
Okay, so
We will submit it.
I'm on page 5.
And you see the topic, the CMP review,
Yes.
right? You've never seen this document before,
No.
okay? Why don't you read it to yourself and see if it satisfies your question of whether or not the 5-year review was actually initiated and began.
And according to this, it doesn't say the 5-year review was completed.
What does it say?
Okay, it says what you highlighted here in the bottom of page 5 of this in minutes states under section C, Mauna Kea Comprehensive Management Plan, CMP updates review. The second paragraph, it states, it is now 5 years since the CMP was approved by the Board of Land and Natural Resources, BLNR, and 5 years is the first review milestone. That's what you highlighted.
How about on page 6?
It says, what you highlighted, it states, is on top of page 6, third paragraph, first sentence. The CMP calls for a 5-year progress report.
All right, thank you. You also stated when Ms. Aluli asked you if the EISPN included any reference to the 30-meter telescope sublease. Do you recall? Do you recall your response?
No.
Well, didn't you testify that it did not include references to the sublease?
I don't believe I said, I thought I said I wasn't certain if it included.
Okay,
That was my answer, I believed.
So, but you reviewed the entire EISPN, correct?
I reviewed most of that particular document.
You're not aware that the EISPN specifically discussed the 30-meter telescope sublease in section 2.3.3 on pages 2-9 of the EISPN?
Could you repeat that question again? Sorry, I didn't hear it.
Well, let me show you. Let me show you. This also is not part of the exhibit, but it's a page from the EISPN, and ask you if you recognize it. It's section 2-2.3.3.
And so, and your question was regards to this document?
This is refresh your recollection of whether or not you saw a reference to the sublease.
I think I'm going to respond to my previous answer to this question. My answer was I wasn't certain, and I stand by that answer.
Okay, if this is a reference in what I handed you, would you change your answer?
Let me see here. Okay, so what would be the question again that's been asked?
Would you change your response? After reviewing the reference in the middle of page 2-9 of the EISPN, specifically section 2.3.3, would you change your response that you were not certain on whether or not there is a reference to the sublease, the TMT sublease?
So, what I'm being
it's actually just a yes or no answer.
Would it change my answer from before that I was uncertain? No, I was uncertain before.
Are you still uncertain now?
And yes, because I haven't read this in its entirety, so I'm still uncertain to what you're referring to, really. I'm trying to decipher what you're referring to in this document here. Okay. This is on, assuming page 2-9.
Do you see the reference to the sublease in that paragraph?
Yes, there's and one reference to the 30-meter telescope sublease in this entire paragraph.
Okay, thank you. So I'll go back to my question. Have you changed your response from your response to Ms. Aluli?
And can you refresh my memory? What
That's okay.
Ms.
Flores, that's enough. Thank you. No further questions, Your Honor.
And will you retrieve the exhibits and mark them?
I will. Thank you.
Next in order, please.
Actually, can I hold on to this for redirect, please?
Which one's that?
The one that's the non-exhibit one on the minutes of the Mauna Kea Management Board.
The minutes?
I'll pass it back, but on the redirect,
Yeah.
I'd like to reference to this. And okay, and I'm going to redirect on these as well. So I'll give them right after I redirect, if that's possible.
Yeah, I think they need to be marked.
Yeah.
If you can possibly mark it in order, it would be better, I think. Yeah.
May I proceed, Your Honor?
Yes, Mr. Shinyama, go ahead.
Good afternoon, Mr. Flores.
Aloha.
Ross Shinyama here again for
Yes.
the TMT International Observatory. Mr. Flores, I want to refer quickly back to that email Mr. Lui Kwan gave you. It was dated April 17, 2009. But before I get there, your email address at the University of Hawaii is ekflores@hawaii.edu. Is that correct?
Yes.
Okay. And I'll show you again the email, which, Your Honor, it is marked as Exhibit A-131. So, Mr. Flores, again, the email that's now marked as Exhibit A-131, I just want you to take a look at the top left corner. You see up there, there's a from line there, and then it says E. Kalani Flores, and then it sets forth the email ekflores@hawaii.edu. Did I read that correctly?
Yes.
Okay, so that is your email, is that correct, on this email dated April 17, 2009?
Yes.
Now, Mr. Flores, I want to go through some of your direct testimony here, but before I do, you don't have any legal background, is that correct?
Yes.
And you're also not a land use expert, is that correct?
Yes.
Okay. Now, if we take a look at page 2 of your written direct testimony, if you could go there, Mr. Flores. And I have some questions for you on your bullet points on page 2. And then, just so it's clear, these bullet points, in your opinion, are mandated by law and statutory provisions. Is that correct?
Yes.
Okay. You don't provide any specific citations to any law or statutory provisions for the bullet points. Is that correct? Outside of the first one, which references Kapa'akai.
Actually, I think in my testimony I do make references to and where these are mandated by law.
Okay. So your testimony is that if I go further into your 26-page direct testimony, you'll provide the cites of the law and statutory provisions that support these bullet points.
Right.
Okay, now going to the Kapa'akai analysis, the first bullet point, Mr. Flores, I'm trying to understand your testimony here. Is it your opinion that the Kapa'akai analysis was supposed to be performed by the Board of Land and Natural Resources before this contested case hearing?
Why would you do it after contested case hearing? That's my opinion. It should be done before.
No, my question is simple, Mr. Flores. Is it your opinion that the Kapa'akai analysis was supposed to have been done before the contested case hearing took place?
Yes.
Okay, and that's based upon your reading of the Kapa'akai Hawaii Supreme Court decision?
Yes.
And that's how you read it, is that correct?
Yes.
Now, going to I want to skip ahead to the fifth bullet point, Mr. Flores, where you discuss or you state UH completing an environmental impact statement for a proposed new general lease that would extend beyond 2013. Did I read that correctly?
Yes.
Okay, and in your prior testimony, you testified that the law that you believe supports that bullet point is the Hawaii Supreme Court decision in this case, correct?
I didn't say that.
Okay.
That's
Well,
not my statement.
Why don't you tell me what law or statutory provision supports your statement that that must be done, that bullet point must be done before the board can approve the CDUA in this case?
Well, first of all, that in chapter under environmental assessment does state an environmental impact statement is needed for this proposed new general lease.
Okay, you're talking about Hawaii Revised Statutes, Chapter 343, is that correct?
Yes.
Is it your opinion, as you sit here today, that HRS Chapter 343 applies to this contested case hearing and the decisions before this hearing officer and the Board of Land and Natural Resources?
That's not my opinion.
Okay. In fact, the HRS Chapter 343 is not applicable to this contested case hearing, is that correct?
It is, because then for any type of project such as this, you have to have environmental, not every, but projects like this, you do need an environmental impact statement done
Sure.
as part of a project for this CDUA as such.
And in fact, for this project, there was an environmental impact statement that was done, and it was accepted in 2010, is that correct?
Yes.
And no one challenged it, is that correct?
I'm not sure if anyone challenged it or not.
Okay, you're not aware of that.
Yes.
Now, I want to keep on going, Mr. Flores, down to another bullet point. It talks about UH taking corrective actions to resolve the incompleteness and inaccuracies in the CDUA HA-3568. Did I read that correctly?
Which bullet was that again?
That's the seventh bullet point, Mr. Flores,
Yes.
on page 2. Again, UH taking corrective actions, and then it keeps on going.
That's correct.
Okay. Now, one of the inaccuracies or alleged inaccuracies that you describe further or later in your written direct testimony is your belief that the CDUA did not take into account the impacts on the entire Mauna Kea historic district. Is that correct?
I don't believe I stated that.
Okay, so one of the alleged inaccuracies in the CDUA is not that it did not take into account any impacts from the Mauna Kea or in the Mauna Kea Science Historic District as a whole?
Could you restate that? Could you repeat the question? I just didn't quite hear it in its clarity.
Sure. Why don't we do this, Mr. Flores? It's getting late in the day, so let me give you something to actually read and cite to. Take a look at page 12 of your written direct testimony. Are you there?
Yes.
Okay. And if you take a look, it mentions the CDUA was incomplete for failing to, and then it goes through a bunch of bullet points. Is that correct? And that first bullet point is disclose the impacts of the TMT upon the integrity of the historic properties within the broader context of the Mauna Kea Summit Region Historic District. Did I read that correctly?
Yes.
Okay, so I know we're jumping around, but if we go back to page 2, that's one of the incompletenesses or inaccuracies that you believe UH needs to take corrective actions upon. Is that correct?
Yes, it's one of them.
Okay. And when you talk about reviewing impacts on historic properties out within the broader Mauna Kea Science Historic District, you're talking about historic properties beyond the TMT project site. Is that correct?
Yes.
And beyond the astronomy precinct. Is that correct?
Yes.
Okay. Have you considered or did you read the Hawaii Supreme Court's recent decision in Kila Kila o Haleakala?
No.
Staying on page 2, Mr. Flores, the last bullet point, you mentioned BLNR, DLNR, and UH ensuring that Native Hawaiian traditional and customary rights and practices are being protected. That's your last bullet point, is that correct?
Yes.
Okay. And you already talked briefly about this with Mr. Fergerstrom, but you are aware that the rights, the traditional and customary rights of Native Hawaiians are subject to state regulation. Is that correct?
Yes.
And that's
yes. Sorry.
And that's based on a constitutional provision found in Article 12, Section 7. Is that correct?
Yes.
And it's also incorporated in the Hawaii Supreme Court's decision in Kapa'akai. Is that correct?
I'm not sure what the entire decision is. So I don't know.
Mr. Flores, and I apologize, you're going to have to go way back on this one to Ms. Pisciotta's questions to you. But Ms. Pisciotta asked you whether the Board of Land and Natural Resources, UH, and TMT has done a Kapa'akai analysis. You recall that line of questioning?
Okay, so who is asking the questions?
No problem. Ms. Pisciotta, Kealoha Pisciotta, asked you a line of questions about whether or not the board, UH, and TMT had done a Kapa'akai analysis, in your opinion. You recall that line of questioning?
Yes.
Okay. And you answered in this fashion, something to this effect. Let me narrow down my answer. And you said it was not reflected, referring to the Kapa'akai analysis, in the CDUA. You recall that testimony?
No. I already called that part of the answer.
You don't recall that part of the answer?
If I had the court report, I could ask her to repeat what I wrote or what I said.
Actually, I don't think Gina would appreciate us asking her to go back that far.
Yeah, but we don't have a court reporter to do so. But so my understanding, if I recall correctly, when the question was posed, my recollection is I said that the BNR was responsible for doing a Kapa'akai. It was a compounded question And so I believe, and when I recall, I clarified in my response that actually BNR is responsible for doing the kapa'akai for this particular TMT project. And that's how I answered to that effect.
And that's actually my recollection too, Mr. Flores. But then there was another follow-up question by Ms. Pisciotta asking whether or not you thought TMT and or UH had performed a kapa'akai analysis, and you testified that, let me narrow down my answer, and you testified that you did not, it was not reflected in the CDOA. And let me just ask my question, Mr. Flores. When you were saying, do you believe a kapa'akai analysis was done by TMT or UH in the environmental impact statement, including all materials attached thereto?
You asking me that question, if it was done or not? Or you asking if I responded to Ms. Scotta's and
No,
question?
I'm asking you if that was done.
The question, I mean, the answer to that is that BNR has to do the kapa'akai analysis. So if it's somebody else doing it, then it wasn't properly done.
Mr. Flores, that wasn't my question. My question was whether or not it is your opinion that UH and TMT performed the kapa'akai analysis in the environmental impact statement.
I'm not sure.
Now, Mr. Flores, you testified earlier that you have been practicing traditional and customary practices on Mauna Kea from the late 70s, early 1980s. Is that correct?
Yes.
Okay, and that includes the astronomy precinct on Mauna Kea. Is that correct?
You know, at that time, I don't even sure there was an astronomy precinct. In fact, I don't even think there was an astronomy precinct at that time.
Okay, fair enough. But you are familiar that currently there is a part of the mountain designated as the astronomy precinct. Is that correct?
Yes.
Okay, and so using that area, you have been practicing your traditional and customary practices in the astronomy precinct, or what is now known as the astronomy precinct, since the late 70s, early 1980s. Would that be a fair statement?
Yes.
Okay. How often do you go up to the astronomy precinct?
You mean now?
Yeah.
Like, we usually go, well, it's not confined to the astronomy precinct, because when you go up there, there's no boundaries or lines to know whether you're in or out of the astronomy precinct. But up top on Mauna Wakea, we roughly go there at least once a month, if not more.
Okay, and how do you get up there?
We go up there with our truck.
Okay, and so you use a vehicle and you use the paved roads that take you up to the summit?
Yes.
Okay. With respect to the astronomy precinct, do you consider the astronomy precinct substantially developed?
Yes.
Mr. Flores, you testified earlier on as well that you find spiritual and cultural practices to be one and the same. Is that correct?
Yes.
Okay. Would your answer be the same for religious practices?
Be the same as what?
Would you consider religious practices as well as spiritual and cultural practices to be one and the same?
It depends on the practice.
Okay. Now, Mr. Flores, do you have that picture of the northern plateau? You had two pictures, one of the with no TMT Observatory and one with the TMT Observatory. And you were using it to refer to your opinion as to the open space characteristic.
Yes, and if you're referring to Exhibit B02R.
Thank you. Yeah, thank you. I appreciate that. So in the top picture, right, that's the Northern Plateau. Is that correct?
Yes.
Okay. And so when you used this particular exhibit, you're using it to support your argument that the open space requirement under the rules is not met, in your opinion. Is that correct?
If the TMT was to be built, yes, it does not meet.
Okay. And so when you are evaluating the open space requirement under the rules, you are, to use your word, telescoping into the Northern Plateau. Is that correct?
No.
You are not? Aren't you in this picture, Mr. Flores, taking a look at the Northern Plateau and only the Northern Plateau?
Well, I'm not telescoping. I'm just providing the picture that's actually in the CDUA.
Okay, so you're focusing on the Northern Plateau, though. Is that correct?
Yes, that's
Okay.
correct.
But when you talk about the impacts to tradition and customary practices, it is your belief that the area that needs to be considered is the entire Mauna Kea Science Historic District. Is that correct?
By law, it is correct.
What law are you referring to?
And state historic preservation law.
Okay, and you, like I said, you didn't read the Kilikolehue Kanaele decision. Is that correct?
Yes, I didn't read that particular decision.
Now, Mr. Flores, you testified earlier today under oath that the statements in your written direct testimony is true and correct. Is that correct?
Yes.
Okay. And you stand by that statement. Is that correct?
Yes.
Okay. Now, you were also here when Peter Mills testified. Is that correct?
Yes.
And Mr. Mills made a statement about certain historic sites not being included in the CDUA. Is that correct?
Yes.
Okay, and you make a similar statement in your written direct testimony as to certain historic sites not being included at all in the CDUA. Is that correct?
That's incorrect.
Okay. Take a look at page 12 of your written direct testimony.
Yes.
Okay. And if you take a look at the 8th bullet point, it starts with disclose the impacts upon SIHP site numbers 16169 and 21447. You see there?
Yes.
Okay, and then if you take a look at the last sentence of that particular bullet point, it says the CDOA omitted any reference to these sites. Correct? Did I read that correctly?
Yes.
Okay, but in fact, the CDOA does at least identify these sites in figure 4.1. Is that correct?
They're in the figure, but there's no discussion on them. Yes.
Mr. Flores, you said it, and I quote, omits any reference. Is that correct?
And I guess you're in, yes, yes, that's correct.
Okay.
What's written there.
So it is referred, though, in figure 4.1. Is that correct?
The sites are in the figure 4.1.
Okay.
Yes.
And do you have figure 4.1 with you?
And yes.
Okay, and again, the two sites, well, the first site is 16169, and that one is on the top left corner of the figure 4.1, is that correct?
Yes.
Okay. And 21447 is on the, I guess, the top right within the astronomy precinct, is that correct?
Yes.
Okay, so unlike Mr. Mills, who claimed that his figure 4.1 that he reviewed didn't have these particular sites, your figure 4.1 does. Is that correct?
It's actually not my figure 4.1. It's in a CDUA, but in this CDUA figure 4.1, it is, these sites are in listed there. Not listed, but they're on the figure.
Okay,
Yes.
and going back to the last sentence on that same bullet point,
Yes.
it continues on to say, even though they are identified in archaeological reports and survey maps. I read that correctly, is that correct?
Yes.
Okay, and in fact, these two particular sites are referenced in the cultural impact assessment, is that correct?
In the cultural impact assessment, I'm not sure.
Okay. Do you know if they're referenced in the archaeological inventory survey that's attached to the FEIS?
Which AIS are you referring to?
Any of the AISs that are attached to the FEIS?
They might be in there, but I'm not sure.
Thank you, Mr. Flores. I have no further questions. Your Honor, I have no further questions.
Thank you. Did I miss anybody for cross-examination? Okay, so Mr. Flores, you have redirect.
I'll redirect in
opportunity,
real briefly.
but it's entirely up to you.
Okay.
Does anybody mind staying? Because I know he's gone the whole day, just a little bit more. Okay, no objections. Go ahead, Mr. Flores. Thank you.
Okay, so let's go back to this last set of questions here. So when I say there's no references. When you read through this, oh yes, the numbers are in here. But when you read through this CDUA, there's no references in here. There's no discussion of these sites. Yet they've narrowed down the discussion and the references to these sites to just 3 specific sites as such, as noted. 16172, 16167, 16166, and there's a mention of 21449, 21438. But there's no references other than that. These other sites that was as mentioned in my testimony, other than the numbers being on this figure 4.1. When you look at the CDUA, it's not just this. It's just a lot of information has been excluded from the CDUA in the discussion. There's no reason why these sites, which are in the astronomy precinct, haven't been fully discussed and referenced in this CDUA. They're only on the map, only on a figure. There's no references in the CDUA in regards to any of these sites that it was just mentioned. And the sites you're referring to is those 2 that were pointed out. There's no discussion, there's no references to them. They're just on the map. In regards to this and here, at the moment, when you go on top of Puku Hau'ula, the northern plateau and in that area is the only area that there's still open space there. Everywhere else where you turn around, there's a telescope around. That's the only place we have left. That's the only place we have left on this mountain. This is open space. This is not open space. This does not improve upon the open space. That does not preserve the open space as identified in criteria 6 of the 8 criteria. Historic properties. The reason why I state that when you look at Mauna Kea, you have to look at it in its entirety. I'm not sure what Kila Kila decision says or not, but it may not apply because I'm not sure Haleakala is a historic district in its entirety. But I do know the Mauna Kea Summit region is a historic district. And the reason it got its designation is because is of its significance. And so when you're assessing any type of project in a historic district, which the proposed TMT project proposes to be built within, you must take into consideration of the impact upon all those historic properties. That is what it states in the laws regarding historic districts and how you evaluate things within a historic district. You can't do isolation of sites and just do impacts upon those isolations of sites. You have to look at the entire historic district. And the proposed project is within the Mauna Kea Summit Region Historic District. And that type of analysis and that type of assessment was not done at all. There's no discussion of it or in the CDUA as such. That's why its faulty, it's inaccurate. It's missing information of what the potential impacts of this project upon the district as its entirety. So this is when the reports are written. The reports are written to get a favorable approval, of course, and that's why I stated that certain information is being left out. So the people who are responsible for viewing this, whether it's the OCCL staff to do a staff report or whether it's BNR, they're not getting the full picture of everything because you're leaving things out. In the CDUA, this is on Section 4, Cultural Resources, page 4-1. It clearly states the TMT Observatory site, the access way, and the batch plant staging area are all within the Mauna Kea Summit Region Historic District. That has not been disputed by anyone here as such. In fact, it even has a statewide inventories of historic places number. It has its own number, SIHP number 50-10-23-26869. It goes on to explain that the criteria that of this district meets all the criteria A, B, C, D, and E as defined in Hawaii Administrative Rules, Section 13-275-6. That's where it stops. It stops right there. It tells what it is. It tells its significance. It tells all the criteria that makes it a historic district. The CDUA does not go any further as to explain the potential impacts of this project upon any aspects of this historic district as a district. That's what's missing. That's the analysis, that's the assessment part that's missing. And that's why the CDUA is incomplete. One of the reasons why it's incomplete and inaccurate as stated in my testimony. Okay. As far as reports, there was cross-examination about reports. Let's go back to Exhibit A66. This is the letter dated January 27, 2011, from the Teresa Donham, D-O-N-H-A-M, Deputy State Historic Preservation Officer of the Historic Preservation Division, to Mr. David Schindler, Principal Investigator of Cultural Surveys, Hawaii. It tells in this document of when these reports were received in their drafts and when the final draft of the archaeological inventory survey was done. And let me just quickly outline these dates. So, I'm just going to read it here. So, thank you. I'm going to read all of it. I'm just going to parts of it. But so the submittal represents the third draft of the subject report. and it was received in the Hilo office January 19, 2011. January 19, 2011 is after the final environmental impact statement was approved. They approved it with a draft report. Okay, and then it goes on. The reason why these reports weren't approved earlier is states why. In response to a review of the first draft of an archaeological assessment for this project, there was a report that was received in May 21st, 2010. The second draft, dated April 2010, addressed comments in our initial review letter regarding sections 1.1, 3.2, and 5.1. However, it did not adequately address our comments regarding section 5.2, mitigation recommendations. The reason why it wasn't approved is because there was deficiencies in those draft reports. And it took them 3 drafts to get it approved. So here is this draft report. A draft report is a basis of the environmental impact statement. Going back to this report, this specific report is significant because the other reports that were done by PCSI were archaeological inventory surveys, which, yes, they surveyed the land to see what was there. The significance of this particular report done by another firm, Hawaii Cultural Surveys Hawaii, was site-specific for the TMT project. The other AIS reports did not address the potential of this project. They just did the survey of the land, of what was on the land. This particular survey report was to look at how this project would impact those cultural sites. So I'm just saying, okay, regardless if the EIS was approved by the governor and so forth, and nobody did so forth, and these reports were later approved by here and there. When this information is then brought into this CDUA, it's subject to another point of review. No matter where the information came from, once it gets put in a CDUA, this whole process, when it goes for a hearing, is to bring up if these aspects of this information or part of this information that's put in a CDUA is accurate or not, regardless of the source of the information. That's why we're here today in this contested case hearing, not just today in this contested case hearing, to see if the information that's presented in the CDUA is complete and accurate, regardless of the source of it. Once they put it in here, it's subject to this review process. Going back, closing, there's an email that was received and as an exhibit A131, which I have no recollections of it. It was in 2009. There's no other part of this email in responding whether I sent something or not. I may have sent some comments. I don't even recall back in 2009. So other than this correspondence here, it doesn't say that I haven't sent anything in. It just says there was a correspondence between this person and myself. But I know back in 2009, I had no clue what a 30-meter telescope was. No clue what a 30-meter telescope was, what it was, and so forth. So whether I responded to this or not, there's no evidence to say I responded or not. It's just that I received the email and I replied to this email as such. The other board minutes that was brought up by UH Council for the the Mauna Kea Management Board minutes, there's nothing in the management minutes that says that shows or demonstrates that the Office of Mauna Kea Management completed a 5-year review. In fact, it shows just the opposite. It shows that they're required to do a 5-year review. And what I presented, I think Exhibit A21 includes this in report, and I also included it in my exhibit as B02H, which is what went before the Board of Land and Natural Resources in June of 2015 regarding the 2015 annual report, status of the implementation of the Mauna Kea Comprehensive Management Plan. And when you look at this report, it clearly states on Appendix A, page 27, under MEU 2, conduct regular updates, MEU 2, when you get to the implementation part, it clearly says 5-year CMP revision interval is 2014. Revision process initiated by OMKM for eventual submission to BLNR. There has not been a submission as of this date, to my knowledge, and to my research, of a 5-year review of the CMP and its subplans. And in conclusion, why is this significant? Because so much has happened within that time frame. But if we take a look at the Mauna Kea Management Plan, the Mauna Kea Comprehensive Management Plan, which is Exhibit B39, also submitted as A9. You look at page 2-3. And then you go into the, so we're on page 2-3 of the Comprehensive Management Plan. You look at section 2.1.4, entitled Issues and Concerns Beyond the Scope of the CMP. And I'm going to read the paragraph. It says, through the extensive community outreach that took place during the preparation of this CMP, see section 4, it became clear that the community had a number of issues and concerns relating to the past and future activities on Mauna Kea, and specifically within the UH management areas that were beyond the scope of this CMP. These issues and concerns are listed below, and policymakers are urged to consider them in the broader decision-making related to Mauna Kea. Let's go down the list. Bullet 1, termination of the state lease between the university and the BLNR. Number 2, bullet, use of ceded lands for $1 a year or nominal consideration. Third bullet, subleases between the university and observatories. Next bullet, extension of the lease beyond 2033. Next bullet, decommissioning. Next bullet, proposed new development on Mauna Kea, including the 30-meter telescope, TMT, and pan-stars. I'm going to stop there. The CMP did not even address the 30-meter telescope. That's why you got to update it. One of the reasons that the scope of this CMP didn't even include the 30-meter telescope. That is why, before you can issue a CDOP for this project, in order to be in compliance with the rules and laws and management plans, that is why the Office of Mauna Kea Management, the University of Hawaii at Hilo, must complete a 5-year major review and update of the CMP, because it doesn't even address it in the CMP itself for the 30-meter telescope, and that's in the document as such, as well as other issues have been brought up. And so, I'm going to conclude. I stand by my testimony. as such, and that if you just go to my testimony, Exhibit B02A, and you go on the list on page 2 of the bullets, once again I say, prior to the BLNR approving any such permit pertaining to the public lands in a conservation district of Mauna Kea, the following actions are mandated by law and statutory provisions to be completed. And that concludes my redirect and my testimony today. Thank you, but for the record, I don't need to have the exhibits, but I will reference that Exhibit A133, the board minutes, does not say at all that a 5-year plan was completed. In fact, it says that it must be done, and that's what's on the board minutes. And thank you. I'd like to thank Your Honor and parties here for being here in this extended time to allow me to finish testimony today, and mahalo nui loa.
Professor Flores, thank you very much. Tomorrow's first witness, so folks can prepare.
I believe we're going to, we're going to, I think we want to go with Debbie Ward, who was actually scheduled for today, and then followed by Kealoha or Paul Neves.
Do you know if Mr. Neves will be available tomorrow? He will. And is his condition such that he can be waiting, or do you need to take him at a set time?
Probably, yeah. I have to talk with him and check, but yeah.
Okay, because the other alternative would be set him at 1 o'clock. There's a good chance we're going to start at 1 in the afternoon. Or restart.
Yeah.
Just so he doesn't have to be waiting, because I know he's not that well. So that would be Ms. Ward, Ms. Pisciotta, Mr. Neves. Was there someone else?
We had actually Ruth Aloua, but realistically she won't be. I don't think we're going to get to her tomorrow. So I think we're going to try to coordinate with Ms. Kihoi to see in February where we can bring on Ms. Aloua.
Okay, let's talk about that tomorrow afternoon, if you don't mind, because we'll have a long break, and I certainly want everyone to be able to prepare. That won't be a problem. We just need to coordinate, that's all. Thank you for your patience, everyone. We'll see you tomorrow morning at 9. Yes. I'm sorry?
There's the matter of the documents I submitted this morning. Did you want to talk about them, or are they just going to go in the file?
I'll take a look at it when it's uploaded.
Okay, thank you.
Thank you.
Sorry, and if I can just note something, specifically during Lanny Sinkin's cross-examination, it was a little glitchy on Naleo, and there was many parts where it was frozen. And also in the beginning of the hearing, also there is some parts that froze for a few minutes.
Well, we'll talk to Naleo about that, and hopefully I can get you a report tomorrow.
Okay.
We will have a court reported tomorrow.
Okay, thank
All
you.
right, thank you.
Contested case hearing for the 30-meter telescope project, a proceeding for the state of Hawaii, DLNR, Board of Land and Natural Resources.